And I hate how fucking disgusting she is. I hate how disgusting Pxie is. She's the grossest woman, the most disgusting, vile, putrid woman I've ever interacted with in my entire life, okay? My complaint was that everybody's making videos and complaining about all this shit, and my 29 videos, of which like 25 of these are just solo fucking jerk videos, are still hosted on Kiwi Farms. Everybody's talking about this. All my shit is so publicly out there. And her interpretation of that is he basically told everybody to go to Kiwi Farms and find out. I was like, okay, thank you. Thank you. That's exactly what I'm saying there. Thank you so much. So just to be clear, this is extortion. I don't know if no one had told her this, but this is extortion. You can't come to me and say, I need you to give me $1 million or I'm going to kill myself and post a note about you to embarrass and humiliate you. That is textbook extortion in all 50 states. That is extortion. You can't do this. Did indicate on one of those live streams that that's one of the worst things you could possibly do to someone. My lawyer objects, objection, Your Honor, hearsay, and then, oh no, and then... I don't think so. I think it was a couple of months. Maybe you guys have the messages. He deleted all of mine, so I can't say 100% for sure, but I don't think it was pretty quick. Just to be clear, I can't delete her messages. That is not true. I can go right now on Discord and look, her messages are all still there. I don't know why she lies about this several times. She lies over and over and over and over and over about this. Also, as every day passes, I will be leaning in more on. I do actually think that Pxie did an elite level fucking scam for that give, send, go money. I'm 99% sure that her parents are able to front all of the money for this lawsuit, and she just collected that money so that she didn't have to stream or work or do anything, and she's just using it to go travel and do shit. But I say based, okay? Queen. That's queen life right there, okay? Okay, well, transcript hearing has attachment. Is it normal for only having 2 hearings after all this time? Nothing is normal. Well, no, I don't want to say that. Oh, here it is. I was going to say it's taken a long time because we both kind of made mistakes. Not really, though. Their side is just deeply unserious. I was going to say I could have went with a cheaper or a different law firm because I didn't realize how unserious. I don't know anything. I'm honest about it, though. I don't really know much about anything. But I assumed that I thought that like federal court and everything was like big boy court and law, and I didn't know how unserious and trolly the other side was. So, but they've also dragged their feet on everything because they have nothing. So this is all, they're just like playing the public relations game, trying to character assassinate me. Oh my God, they're trying, but, stuff is going to come out in motion soon. That's just unbelievable. My life is just a very unbelievable life, okay? I don't know why. Jesus. Does it seem like it's almost over? I don't know. I mean, it's been over for a long time. It's just a matter of like what level are they going to try to kick it to. Like I said, if we get lucky, before I would have said like 1% chance of winning on that, the motion to dismiss. Now it feels a lot higher, but we still probably shouldn't. The motion on the summary judgment is what we should win on. And then if they kick it to court, I mean, fuck it. At this point, well, let's go to trial. Let's have our fun, I guess. I don't know. Why not? My faith in the justice system, though, is at all-time highs every single time I open literally anything having to do with any of this. Because the judge is a fucking god, okay? Okay. Real quick, I'm just going to read the judge's order relating to the sealing of the transcript, okay? Okay, coming down here. Hello. Baby blasphemy, what? Oh, yeah, we got this. Okay, I already got it. Okay. Okay. Sorry if my background looks weird. I'm in your mom's house right now. Got him. All right. Order on plaintiff's motion to seal hearing transcript. So if you weren't aware of this, actually, you know what? It's going on over here. Okay, so back in June, plaintiff Jane Doe, very important to keep her identity private because of how private she's been through this whole ordeal. Okay. Plaintiff Jane Doe was seeking a preliminary injunction against me because either her or her law firm or both don't know what an injunction is for. They don't know what a party to a hearing is. They have no idea about anything. But the idea was they wanted to enjoin or stop me from being able to post her video online, even though this would have been more appropriate for the person who actually posted it online, or maybe even other parties like Kiwi Farms that were hosting the video. But I don't know why they decided it. Well, I do know why. It's because she wants that money. Wait, hello, test. Oh, wait, is this a bot? Oh shit, I'm sorry. Is this a volume thing on the bottom of this? Oh shit, have I been fucking with this the whole time? I didn't even realize. Sorry. Oh my god. Okay. Is this okay? Okay, wait, sorry. Okay, I'll stop touching it. My bad. Okay. Whoops. Fun. Okay. Okay, no fun fact for you now. Fuck you. Fuck this mic. Okay, I'm just kidding. Nope, wait, too loud. Hello, 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 hello. Okay. Stop. The top mutes. Yeah, I see that. Oh, sorry. There's no compressor. Okay. Hello. Okay. Stop. You have to... Are you supposed to speak up here? No, you speak down here. Shut up. Oh, maybe it can be further away from me. Hello, testing. Does this sound okay? Wait. Wait, nope. Hello. Okay, this is good, right? There we go. Okay. Plaintiff was seeking first a temporary restraining order, then a preliminary injunction against me. We had a hearing for that. I would argue that the hearing went horribly for them. So they tried to seal it immediately after, even though it was a public hearing, which is dumb. But now we've finally gotten an order from the judge on whether or not that hearing can be sealed. Okay. What was the fun fact? In France, it is illegal to have unlimited refills and drinks. Did you know that? I didn't know that. That's crazy, chat. Okay. Show screen. I don't know if I can do that. There you go. That's what you get. That's what you're getting, okay? Okay. Order on plaintiff's motion to seal hearing transcript. This matter is before the court on plaintiff Jane Doe's motion to have a June 3rd, 2025 evidentiary hearing transcript filed under seal. Defendant timely responded, to which plaintiff timely replied. Accordingly, plaintiff's motion is ripe for disposition. Ripe meaning now is an appropriate time to make a ruling on it. After a careful review of the motion, response, reply, relevant authority, and for the reasons discussed below, plaintiff's motion is, that's it. I don't have my glass on. Is that denied in part? Is that granted in part? Or is that just in bold letters? Denied. Just completely. Looks pretty bad. Yikes. Actually, I should have my glass on. Hold on. My intellectual look. Now put the dock in the middle and split your face on both sides. Yeah, is that what you want? Okay. We're in intellectual mode, okay? Hold on, sorry. Like this, almost. Okay, I'm done. Stop. Okay. Okay. Background. On April 4th, 2025, the court held a hearing on plaintiff's motion for a temporary restraining order and preliminary injunction. At the hearing, District Judge Jacqueline Becerra denied plaintiff's motion for a TRO and referred the remainder of the motion to the undersigned for disposition. Accordingly, the undersigned held a hearing on June 3rd, 2025 on plaintiff's motion for preliminary injunction. That hearing lasted approximately 2.5 hours and saw both plaintiff and defendant testify as to the issues raised by plaintiff's motion. Additionally, the hearing was open to the public. There was no request made to the court either before or during the hearing to seal the courtroom in any fashion. And accordingly, there were others in attendance beyond the undersigned, court staff, the parties, and their counsel. Now, it's so crazy. Now, it could be that the judge is just a massive fan of mine, and somehow I'm rigging the whole thing, because I feel like I've said all of these things multiple times, and all of the Kiwi Farms lawyers said they didn't matter, but, if you want to have something sealed, it's important to get things sealed before you have the thing happen. I don't think that the court looks fondly upon people playing with the process where they're trying to seal shit in order to hide stuff from the public when it's obvious that that's the intention. If you want to have a closed door hearing, you can make that statement ahead of time. We want to have a hearing, we want it to be under seal, and then you set that up. You don't have a hearing and then try to seal it afterwards because you think it went bad for you, especially by making bullshit excuses for it. But that's just my impression. I could be retarded, and maybe the judge is also wrong, and the Kiwi Farms people are right. It's possible. Who knows? Plaintiff, however, filed a motion to seal the hearing transcript, here referred to as the transcript, citing the existence of highly sensitive, private, and confidential information, including personal details with regards to the identity of Ms. Doe, details concerning Ms. Doe's harm and suffering because of defendant's actions, and sexually explicit content. The filing of the transcript indeed incited much fervor to the end of a concerned call from the court reporter regarding next steps. Given plaintiff's allegations as to the potential harm resulting from the testimony, a then lack of an existing protective order governing the party's actions as to, for example, a procedure for dealing with inadvertently disclosed confidential information, were there any, and a litany of then recently filed motions, including for a gag order tangentially related to elements of the party's testimony, the court granted in part plaintiff's motion to seal, pending further order of the court. Yeah, so it's just saying there's been a lot of back and forth, basically, about whether or not to seal or not seal this, and yeah, okay. In the intervening period, we've addressed several of the party's outstanding motions, and, now being well acquainted with the equities of the case, issued the foreshadowed further order of the court. Now, I like it whenever the judge writes on stuff because I feel more sane, because I feel like opposing counsel is crazy, Joan. I'm talking about you, okay? Despite all of her love letters that she writes to me and every motion that she files on behalf of her client, who I assume is paying, I feel like their arguments are just unhinged. I feel like they're just insane arguments. I feel like this statement of now being well acquainted with the equities of the case, every time I see the judge write on this, I feel like they're continually coming down the other side. And now being well acquainted with the equities of the case makes me feel like he's even more familiar now with everything going on here. And they don't stop coming, the rulings. Okay. Applicable principles and law. Pursuant to the... What is this guy? I can't tell if he's riffing or this is stuff he's reading. I always riff. What are you talking about? And then I made a really funny joke at court, and then the judge looked at me, and then he's... No, I'm just kidding. Stop. Okay. I'm reading the ruling now. Okay. Pursuant to the local rules of the Southern District of Florida, unless otherwise provided by law, court rule, or court order, proceedings in the United States District Court are public, and court filings are matters of public record. The general public possesses a common law right to access judicial records, and judicial records are presumed to be public documents. Well-established 11th Circuit case law protects this common law right because once a matter is brought before a court for resolution, it is no longer solely the party's case, but also the public's case. So this is the thing I've been saying over and over and over again. Pxie wants to do all this stuff like in the shadows and have everything sealed and everybody anonymous and everything redacted. And it's like, bro, for like a Substack, okay, you can do whatever you want, but like if you want to go to court, well, these are like public filings. This is like public interest now. Like you can't hide everything over and over again. Like you have to like, we're in court now. It's time to be adults, you know? Analysis. Based on these rules and principles, when a party orders a transcript of a hearing from the court reporter, transcripts filed on the docket are presumptively public judicial documents. As such, they become part of the public record in a case, and accessible to the public like any other public document. The motion here seeks to alter that rule for this filing. Thus, the movant has the burden to overcome this presumptive right of access to the filed transcript. So the movant is the person who files a motion, because you're the movant, right? And then presumptively, everything is public, so you have to make an argument for why should this thing not be public. Thus, plaintiff has the burden of showing good cause why the right of access should be limited. Thus, a movant must make a specific showing of a compelling cause as opposed to relying on stereotyped or conclusory statements. Oh no, so you have to make an actual argument. You can't just, write random shit. Good luck. Oh, esports Batman, already salty. One of the many lawyers who has been proven to be a total fucking legal retard with regards to this. But I like it. How mad that every quote-unquote lawyer on the internet that was following this case is so brain broken by me. I don't know what it is. I don't know if it's the fuckboy chain. I don't know if it's the Ray-Bans auto sunglass featured prescription lenses. Okay. I don't know if it's my stylish DGG merch. Okay. I don't know if it's my 38-inch arms. I don't know what it is, but something just triggers the fuck out of you guys and it breaks your brains, and I'm here for it. I love it. Okay. Wait. Sorry, I was seeing if I could have cat ears, but I don't have those. That's okay. We'll live. Okay. Thus, okay. Plaintiff relies primarily on 3 cases to support her assertion that the subject matter of the transcript is traditionally considered private, not public, none of which aid plaintiff's case here, or for that matter, are binding on us. Okay, so I told you over and over again when these guys file motions, I always read the underlying cases because I'm curious, okay? And none of the cases ever apply. Like, none of the shit they cite, I'm like, this has nothing to do with what you guys are talking about. And the judge reads cases too, and I love that. Number one. Number two, I think that generally speaking, when it comes to federal court, it's nice if you can cite from your from the particular district you're in, or at the very least, you want to cite in the circuit that you're in. Now, you don't have to cite from other, or you could cite from other circuits, but like generally speaking, I think the particular circuits respect their stuff more than anybody else's because it's their circuit, right? And that's how the court system in the United States works, you know? So Florida is in the 11th Circuit, I believe. And so you want to cite, ideally, 11th Circuit cases when you're talking about stuff that you want to apply in the court area that you're filing your case in, you know? Okay. First, okay, so now the judge is going through the cases that these lawyers cited, okay? First, in U.S. versus Amadeo, a RICO action, the Second Circuit considered whether a portion of a report created by a court officer appointed pursuant to a consent decree to investigate allegations of corruption in a local union was improperly unsealed. Plaintiff cites Amadeo for the proposition that, quote, financial records of a wholly owned business, family affairs, embarrassing conduct with no public ramifications, and similar matters will weigh more heavily against access than conduct affecting a substantial portion of the public, end quote. Amadeo ultimately concluded the report had only a marginal relationship to the performance of Article III functions, as it was not filed in connection with a request for action by the district court. And further, the privacy interest in question was the attorney-client privilege, which the clients had, in effect, waived by way of the consent decree. But Amadeo is inopposite. As to the point of, inopposite, I think, is lawyer fancy speak for, I think it says the opposite of what you wanted to say, or it's standing on the other side of what you wanted to say, right? I believe. As to the point of embarrassing conduct with no public ramifications and similar matters, which we assume by process of elimination in the phraseology plaintiff was emphasizing and citing Amadeo, that is not what is before us here. And this conclusion is supported by other cases plaintiff cites. Chief among those other cases is U.S. v. Kravitz. In Kravitz, the First Circuit considered a journalist's appeal of a motion to unseal certain records which had been denied by the district court because the documents in question contain matters that are predominantly personal to Kravitz and there is not apparent justification for their general publication. As to the defendant's medical records, the court acknowledged its sensitivity to the fact that medical documentation may contain information beyond the diagnosis and treatment information that is likely to form the basis of a plea or grant of leniency, such as a history of drug use or testing for sexually transmitted diseases, and thus that the presence of such information may weigh more heavily against public access. But Kravitz also noted in remanding that subjective remarks about a patient's demeanor, character, and mental state are sometimes a part of the record. Wait, am I missing any good footnotes? One. Where was my? Oh, no. Okay. This is a quote from that case. Oh, actually, we'll read this, I guess. Leviton's claim of privacy in his medical records, however, may lose some force in light of his prior publication of the information that he now seeks to protect. Remember, okay, the general claim that is made is don't be public, don't talk publicly about your case, because the reason is especially if you're not a lawyer, and even if you are a lawyer, you don't know what you're saying publicly that might come back to bite you in the ass later on. You know, one of the big criticisms that I gave of Pxie before anything was when she published that Substack against me, she basically totally closed the door on ever reaching any kind of a settlement with me, because this is a civil case. The only thing that's going to come out of this is civil stuff. The only thing, more than you even know, the only thing that will come out of this is civil stuff, which means money. That's all that's going to cost me. So if you write a Substack and you are attacking the fuck out of me, writing the most unhinged shit possible, well, the only thing I can lose in court is money. You've already cost me more money on your Substack. Well, now I'm never settling. What is the incentive that I ever have to settle that case? So now you fucked yourself there. And you got to be careful because stuff that you're publicizing, in a case where you're trying to keep everything private, is going to hurt your privacy claims and other claims you're going to make later on down the road, right? So this is not good. Don't do this. Not a good thing. But, okay. So the quote from here is, the interest in privacy fade when the information involved already appears on the public record. And then this case noting that prior publicity weighs strongly against sealing. If Pxie would have sued me without making that Substack first, and it would have been private, she would have had much stronger privacy claims here. But she's trying to have it both ways. She's trying to milk the cow on, I want all the publicity possible so that I can extort, blackmail, and bury Stephen if I can. But I also want everything in court to be private as possible. You can't have it both ways. You have to pick. You can't do that. In his public sentencing hearing, he articulated not only the full panoply of ailments from which he suffers, but also the dire predictions for his health should he fail to take immediate steps to improve his condition. So this is all about another case, okay? All right. Importantly, here, plaintiff's request that the court seal the transcript is ostensibly to protect deeply private, sexually explicit, and mental health-related testimony from being broadcast over 1 million online followers by a political streamer who has a documented pattern of weaponizing public proceedings for harassment, monetization, and spectacle. Okay? So, number one, with all caps, fuck you. Okay? For you to weaponize, I'm speaking right now to Jane Doe, okay? For Jane Doe to weaponize the fuck out of her Substack, and now the court system, which it really is, which is ironic, given that she says she wants to go to law school, right? For her personal petty squabbles that are being funded by mom and dad after scamming the public for money for it, for her to weaponize all of that and then cry when I just want to read my own public filings, which is my right as a public citizen because you filed a federal lawsuit in public court about it, is crazy that I'm weaponizing public proceedings by reading them. Capital F fuck you, okay? One, as compared to Kravitz and to the court's knowledge, the transcript does not contain any discussion about plaintiff's medical records or anything to do with plaintiff seeing or being treated by a physician or other mental health professional. So the emphasis in Kravitz that medical documentation may contain sensitive information is inapplicable here. Second, plaintiff has, in several public filings, been quite forthcoming about the mental health and other effects of the events surrounding the video and has been from the start. For instance, as to mental health, plaintiff's original and operative complaints both contain the same passages regarding her struggles. Compare, in the very first complaint, plaintiff feels increasingly humiliated, mortified, and depressed and starts feeling suicidal on or about December 11th, 2024. She starts writing suicide notes. Look, that's so cute because my birthday is December 12th. She wanted to have her extortion of me ready for my birthday. How nice. Plaintiff messages Bonnell and tells him that she is, quote, just tired of living anymore. It's a matter of time until my family discovers what happened. I feel like the best thing to do is for me to kill myself and schedule a post just detailing my feelings on what happened to try and ensure a situation like this doesn't happen again, end quote. Later on, there is a $1 million demand for money tied to this, by the way. Every fucking retard, Kelly Jean, I'm sorry included, that's like, Destiny should have just settled with her. Destiny should have just settled this before it went to court. I am never paying $1 million out to a blackmail extortion attempt, okay? Fuck you, all right? And $1 million. Remember, the most that she's qualified for, the most she can win in this case is like $150K. That's the like statutory cap, all right? But whatever. What she sued me, by the way, the demand letter was for $15 million, but what, it is what it is. And then 19, plaintiff tells defendant's close friend about her suicidal thoughts, that she cannot bear the humiliation and harassment she is enduring, and that she wants to ensure Bonnell never does this to her or anyone else ever again. Item 21, plaintiff continues feeling depressed and suicidal. Item 22, same as the complaint. And then here, the original plan was basically for me to commit suicide and schedule a note for after I died, detailing what Stephen had done and hoping that everybody would forever know what he did and be able to stay away from him and be able to be more wary and cautious. Again, tied with a demand for money. This is textbook extortion, by the way, but the original complaint has been live on the public docket for many months. The plaintiff perhaps added additional characterizing details, for example, support from her friends, or more emphasis on why she experienced such thoughts, during the June 3rd, 2025 hearing, does not change the fact that the information has already been made publicly available through plaintiff's own filings. What's more, the transcript is one of a public hearing. So plaintiff had not only published this information in her earlier pleadings, but also was, in the moment, speaking in a public forum. And then footnote 3, and as to things of a deeply private or sexually explicit nature, plaintiff has not raised any specific elements of the transcript in her argument. But it merits noting that she has also long publicly stated many of these allegations and or included similar factual information in her briefing. Compare in the complaint allegations regarding plaintiff's prior relationship experience with, docket item 90, testimony regarding plaintiff's prior relationship experience and perception of defendant prior to their sexual encounter, and then in docket number 21, unsworn statement of Ms. Brooke recounting allegedly receiving messages of a sexual nature from defendant. Okay. Basically, you're adding all this stuff to your court filings, and it's undercutting your argument that you want stuff to be sealed or private, which is, again, a thing I've said over and over again. And relatedly, another of plaintiff's cited cases, Prospero versus Prescott, is similarly unavailing. Prospero, ooh, typo. That's okay. We love our judge, even if he makes typos. He's a king. Prospero regards a motion to exclude expert testimony where defendants argued that didn't happen. Sorry, hello? I don't know why that just happened. Hello? Okay, weird. Okay, mic glitch there. Prospero regards a motion to exclude expert testimony where defendant argued that certain of the information in the expert's testimony, including content from a treating physician's deposition, was designated confidential under the existing protective order. At the time of the hearing, there was no existing protective order, save a recently filed unright motion for protective order governing discovery. Order granting in part, motion for protective order, governing discovery, detailing breakdown of communications. So this is basically saying we had the hearing, there was no protective order in place. Like, what do you, like, hello? Yeah. But even then, none of the protective orders regarding discovery, not plaintiff's draft, not defendant's draft, and not the final version entered by the court, are designed to shield in its entirety a public court transcript, nor should they be, because this is public court. We're here for, this is a public court filing, okay? Where were we? Footnote 4 was, plaintiff's last mainstay case as to the nature of the material discussed is also inapt. This is a 2001 case they cited. This regards a petition filed in the public docket in contravention of 2 federal statutes that plainly prohibit the FEC from disclosing information concerning ongoing investigations under any circumstances without the written consent of the subject of the investigation. So they're just trying to make all these arguments like, well, look, it was sealed here, but like I'm guessing in this case, well, no, this was sealed because it was an ongoing investigation by the FEC or something, right? And then for footnote 5, plaintiff has also filed a motion for protective order governing public commentary by trial participants, but that regards public extrajudicial statements, so we will not address it for the purpose of deciding on plaintiff's motion to seal the transcript. Okay. Protective orders until Federal Rule of Civil Procedure 26C minimize abuse of the discovery process. By the way, an abuse of the discovery process might be including fake or damning material in your filings that have nothing to do with your court case, but are just trying to slander or defame defendant. Just saying, just randomly putting that out there, you know, maybe. That might be abuse of the discovery process. Maybe. Now, you know, that's not my call to make, but because parties often resist the exchange of confidential information, parties regularly agree, and courts often agree, that discovery information will remain private. This is because while there is no question that the press and the public jointly possess a common law right to inspect and copy judicial records and public documents, private documents collected during discovery are not judicial records. Thus, the common law right of access does not extend to information collected through discovery, which is not a matter of public record. So what this means is that, like, so me and her, well, only me, because they haven't given me fucking anything, but in discovery, you're supposed to trade information to the other parties so that they can build their case and figure out what to do. That's not necessarily public information until it shows up like in a court filing somewhere, right? On June 3rd, 2025, as of the June 3rd, 2025 hearing, the parties had apparently agreed to freeze discovery pending the court's ruling on plaintiff's motion for protective order governing discovery. While there was an unright motion on the docket, there was no entered protective order governing discovery or any confidential information as of the June 3rd, 2025 hearing, so there was no discovery information that at the time could have been seen as having been designated as confidential under such an order. The transcript also does not reflect any inadvertent references to plaintiff's name or particular identifying information that could cause her to be personally identified. They lied when they said that. as evidenced by the fact that there are no objections or other expressed concerns to that effect. The court allowing the use of Jane Doe for confidentiality at hearing and clarifying for plaintiff that she need not say her name at the hearing beyond Jane Doe, meaning that during the hearing we were being careful not to reveal somebody's name so that we wouldn't run into this issue. And though we disagree with plaintiff that any of her testimony at the hearing would be considered medical or treatment-related in nature sufficient to merit a privacy claim, even that information which plaintiff alleges was private could already, at that point, be found in briefing on the public docket. Plus, again, the June 3rd, 2025 hearing was public. Plaintiff's showing of good cause to seal the entire transcript thus falters. Though we agree that the entire case here is by its very nature sensitive, a federal judicial action has now been filed that, absent a compelling and specific showing, is now a matter of public record. Meaning, you wanted to file in big boy court, so now we are at court. This is public now. You don't get to hide and make everything private and anonymous and redacted and sealed. Like, we're in public, okay? Accordingly, plaintiff's motion to seal the entire transcript must be denied as good cause of a compelling and specific nature has not been persuasively shown. Conclusion, for the foregoing reasons, plaintiff's motion to seal is denied. Okay. Now we have lay hearing. I won't pre-comment on this. We'll just read it down. I'm going to give you my thoughts as we go through. Destiny, reply to The Hague as well as up. They say you waived your right in a meet and confer because of an email. It's a joke. I'm so happy. Every time the judge writes on this, I'm just so happy. God, I'm so happy. Bep, thank you for the 20 gifted subs. This hearing was just so wacky, dudes. Destiny, has she said anything new about this whole thing? No, once I started going harder accusing her of scamming everybody on her Give Send Go, she blocked me again on Twitter. They're still trying to go with the Hague shit? Yeah, it's not Hague, it's Hagel Mary. Get it? Ah, stop. But yeah, these are like Hail Marys. Ignore that last pun. Okay. Can you clarify your vague post? Nope, but it'll start showing up soon. And there's some stuff that's been in these filings that will never show up again. But I can't say much more. We'll see. I have to wait. I will say that all of it, there are a whole lot of people who should be unbelievably ashamed of themselves. But we'll get there. Okay. So the following procedures were held. Okay. This is our court hearing from June 3rd this year. The Deputy Clerk, the United States District Court, is now in session. The Honorable Edwin G. Torres presiding, calling case Doe Bonnell, case number, blah, blah, blah. Okay. What was this hearing in regard to? This is our preliminary injunction hearing. Counsel, please state your appearance, starting with the plaintiff. Mr. Lage, I don't know how to pronounce his name, but this is Pxie's lawyer. Joan Peters did not show up for this hearing. I don't know why, but... Good morning, Your Honor. Gus Lage, Carlos Garcia Perez, law clerk, Miss Garcia, and the plaintiff, Jane Doe, is present. Mr. Raskoff. Good morning, Your Honor. Bob Raskoff from the Bilzen-Sumberg firm, along with my colleague Patricia Patino, and our lead counsel from Los Angeles is Andrew Bretler from Burke Bretler. So for court stuff, in order for you to appear at the venue, you can't be from another state. Like somebody from California can't practice law in Florida unless they're licensed down there. However, if you get a law firm to sponsor you, what the law firm can do is have you file, it's a pro hac vice filing saying, I would like to appear down here, and then this other local law firm is sponsoring my appearance here. So the lead counsel in my case is the Brettler law firm from California, and then Raskoff and his law firm are the Florida-based law firm that's allowing them to come in, basically, right? Okay. Please do voices? No. Destiny, I'm begging you to actually research narcissistic abuse strategies. Your life will be so much better. Is that for me? I saw that some people are now claiming that I'm a narcissist. Okay, thank you. I love my psychoanalyzers. Can you explain, like I'm 5, what a preliminary injunction is? So a preliminary injunction, an injunction means that you're enjoining or stopping a party from engaging in certain behavior, future behavior. Preliminary injunction is before the trial has happened, you're, in an extraordinary measure, you're asking the court to step in and stop somebody from doing some actions, to enjoin them from some behavior. But that's an extraordinary step, right? You're seeing a lot of TROs, temporary restraining orders, and preliminary injunctions right now in regards to the Trump administration, right? Yeah. Okay. Good morning, Your Honor. Okay, this is my lawyer, the Giga Chad. Okay. Good morning, Your Honor. Andrew Brettler from Burke Brettler. We're also joined by Mr. Bonnell, our client. The court. Anytime it says the court, I believe that's the judge speaking. Good morning. Everybody have a seat. There's a preliminary injunction hearing that was referred to me for disposition by Judge Becerra. I took a look at it and decided that I couldn't resolve it without probably hearing additional evidence or response from the parties. So that's why I scheduled a hearing when I did. So I appreciate everyone's cooperation. I think I scheduled it on Friday, short notice, so I appreciate everybody accommodating it to get the matter resolved. So let me turn to counsel for the plaintiff and tell me what witnesses, if any, you wish to call. Mr. Lage stands up, Pixie's lawyer. Your Honor, at this time, if Your Honor needs us to get further information, we would call the plaintiff and we would also call the defendant. Now keep in mind that for the first time yesterday, right, the day before this, they added Abby to the case. Now, she didn't show up, obviously, but I believe it was the day before is when they threw on her statements saying that I'd sent her videos of Pixie. Never have. This is bullshit. There's a reason why she's dodging subpoenas and why they've offered no evidence of this, but this was the day before they had added her, so obviously she's not here or anything, but okay. And Destiny, amateur detractors are narcissists. Oh, I'm sorry. Well, I don't think Pixie's a narcissist. I don't think any of the people involved in this are narcissists. But... Okay, so Pixie's lawyer. Your Honor, at this time, if Your Honor needs us to get further information, we would call the plaintiff. We would also call the defendant. The judge. Okay, on behalf of the defendant, Andrew, we would call the defendant, Your Honor. The judge says, okay. So why don't we do that? Why don't we take we don't have to take all day for it, just because I've already reviewed the affidavit you filed in support and the declarations and the supplemental declarations, but I think it would be useful to get some of the information clarified on the record. So go ahead and call then, let you direct your client. Pixie's lawyer, Mr. Lage? Zepsip put it in chat, how do you pronounce it? Your Honor, in order to make this as efficient as possible, if there's areas of inquiry that you wish us to address, I'm happy to do so. The judge. In particular, I guess the issue is, one of the issues that I have is when did she become aware of the problem and what occurred in the interim between that awareness and when the lawsuit was filed. So remember, it's like Lage, like G-A-G-U-E. Am I supposed to know how you pronounce that? Gegu? Geju? Okay, that didn't help at all, but thanks. Okay. Oh, Gage. Lage and Gage. Oh, you just spelled Gage incorrectly. Fuck you. Okay. The reason why the judge... Do I need to explain why they're asking questions? I don't know how much... I feel like I've explained this a lot. I don't know how many people understand everything by now. The reason why he's asking is because if you're filing a TRO or a preliminary injunction, the reason why you're filing these things is because you're saying, like, this is an emergency. I need the court to step in right now, because at the end of the day, our civil courts are courts of equitable relief, is the way you say it, right? Basically, the court is here to make you whole again after a bad thing has happened. But if there's an ongoing thing, sometimes these ongoing things will cause irreparable harm. That's one of your qualifiers for having a preliminary injunction, is you have to show that the harm that's going to be caused if the defendant is allowed to continue to act in the way that he is so bad that the court can't help me. So like an example of this might be, let's say me and somebody else recorded a porn video and I'm going to publish it and I want to publish it. And they're saying, no, I don't want that person to publish it, but I haven't published it yet. Okay. If I haven't published it yet, and I'm going to, you might file like a TRO or a preliminary injunction saying he can't be allowed to publish this while we do the court case, because let's say that he publishes it and then we do the court case. Well, now I'm fucked. I can't, like, you can pay me money, but I don't ever want this out there. This is irreparable harm. Like, I'm fucked. There's no way, you know? So that would be like an example there, and you can think of other things too, but basically anything that would make the court incapable of resolving an issue or making somebody whole, a party whole again after a given dispute or claim. Okay. Her lawyer says, very well, Your Honor. At this time, we would call Jane Doe to the stand. The judge says, okay. The deputy clerk requests, please state your full name and spell your last name for the record, please. Her lawyer says, Your Honor, for purposes of confidentiality, can we continue to refer to her as Jane Doe? The judge says, yes, for the purposes of this hearing, that's fine. Her lawyer says, very well, thank you. Pxie says, sorry to clarify, do I say my real name now? The judge says, no, the court reporter will know. Pxie says, Jane Doe. The judge says, thank you. Thereupon, Jane Doe, having been first duly sworn, was examined and testified as follows. Direct examination means that your own lawyer is asking you questions. A cross-examination is when the opposing counsel lawyer is asking you questions. Okay, so this is direct examination. Her lawyer is asking her questions to get stuff on the record. Okay, so her lawyer, Miss Doe, do you know the defendant? Yes. And how is it that you know the defendant? He was my friend for around 5 or 6 years. Okay, where is it that you first met the defendant? I first met him in Florida, but I knew about him online beforehand. We had a couple of debates and conversations privately. When we're speaking about the defendant, who is the defendant? Stephen Kenneth Bonnell, Destiny. So this is her first lie. I am Stephen Kenneth Bonnell the second. My dad is Stephen Kenneth Bonnell, okay? Just saying. Just kidding. That's not that important, but... Okay, can you point him out for us, please? Yeah, the individual with the banging blue suit and amazingly fluffy curly brown hair. Yes, that is me. True. And as a result of your conversations with Mr. Bonnell, did you at some point have an intimate relationship with Mr. Bonnell? Yes. All right, was that? Where did that intimate rendezvous take place? In Miami, Florida. And what was the date of that rendezvous? I believe it was around September of what year? 2020 or 2021. It's da-da-da. Okay, I just want to say on a personal matter, okay? So I was incredibly stressed for this hearing. Just because I've never obviously done a court hearing before. Obviously, I don't want to screw anything up, okay? I read all of my declarations. I reread tons of our chat logs. I went over so much info for this so that I was ready. The fact that she shows up and doesn't fucking know anything about what the fuck we're in court for. How do you not know the date that we met? This is all information. You still have this in your DMs. I can't delete your side of it. I just want to say that triggered the fuck out of me, but whatever. Yeah, if it's all a joke to her, okay, I guess. The judge says, so her lawyer was going to ask another question leading up to, and then the judge intervenes and he says, when did you first meet or talk with Mr. Bonnell? And then Pxie says, posture? No, fuck you. Pxie says, I talked to him. I started around 2020. I had just transferred universities and I was like lonely. So I was like, I'm going to live stream and see if I can make friends that way. And because my family is inherently very political, I started talking politics and then connected with Mr. Bonnell. And then her lawyer asks, leading up to your intimate rendezvous with Mr. Bonnell, had you had conversations or messaging in relation to that upcoming rendezvous? Pxie says, yeah, we talked about it beforehand. We had a lot of conversations about consent and the importance of consent. I was not super sexually experienced, so I was very afraid of, like, accidentally leading somebody on or getting sexually assaulted. So we had a bunch of conversations about consent beforehand. Okay. Well, when you say that you had conversations about consent, did you have conversations about consent relating to dissemination of information relating to your rendezvous? Well, I told him ahead of time that I wanted to keep things really private. I didn't want people in general to know about our sexual encounter, that I didn't want that information to be, like, out in public, stuff like that, okay? I mean, it's all, we've already done this here. I don't care about this anymore. I don't care about this, guys, in terms of what they, but I will say that, like, if I was her lawyer going into this, okay? So there's two things. One, when you're being asked to do a deposition to give testimony, don't speculate. If you don't know the answer to a thing, then don't answer, okay? Number one. Number two, answer only what you're asked. Don't give a whole bunch more information, because at the end of the day, all it can do is hurt you, right? Because the opposing counsel is going to be looking for anything that you say that can be used to impeach your character, to a contradiction, something else to question what you're saying, right? Okay, number two. Now, I would say number three, I don't think this should matter as much. You should keep it in mind, but as long as you're not lying, it shouldn't matter, okay? But number three, if you are going to court for a claim, you need to be locked in on what that claim is, and you need to very clearly state what you think the violation of that claim was every single time. One thing you'll notice is that, so if now you can't tell your client to say this, but if I was going to testify, okay, to a thing where I think the other person did like a crime or a bad action against me, I would be crystal clear every single time. I never wanted any of this shared with anybody. I did not want my video shared with anybody. I never gave permission to share this with anybody. That would be my claim every single time, okay? You don't want to skirt around this language, because this is the sole claim that you have in federal court, and this should be the most important part of your case. Just saying. Keep that in mind, okay? I didn't want that information to be like out in public, stuff like that. The lawyer said, why? She said, his community, and not just his community, but to be fair, the internet can be like a really vicious place, and I didn't want people to claim that, like, oh, he was only being nice to me because he wanted to sleep with me, because we would debate online politically, so we would go back and forth on subjects, and I didn't want people to just claim, like, oh no, he's just being nice to you for that, instead of, like, evaluating my arguments on the merits of what they are. Then the judge interrupts, and the judge says, now, what do you mean about his community? Pxie says, he's a live streamer, so he has a large platform of a lot of followers. They refer to themselves as DGG. The judge says, as what? She says, DGG. That's their community name. The judge says, DGG? You mean like Yi wins? No, I'm just kidding. Judge says, DGG? She says, yes. And there are people who follow him, who really agree with his ideas, thinks he's like super cool, and yeah, try to support him and his endeavors. And then her lawyer says, well, when we're talking about the size of that community, how big is the community that follows Mr. Bonnell? She says, well, he has over 840,000 subscribers on YouTube, and that's just one of his platforms. How many platforms is Mr. Bonnell on that you're aware of? He's on Kick, Instagram, YouTube, and I think he's doing TikTok as well. Do you have any knowledge as to whether streaming is the main source of revenue for Mr. Bonnell? Yeah, and I'm under the impression that live streaming is his main source of revenue. Now, what happened at the encounter? Was it recorded? Parts of it were recorded, so it wasn't the entire thing. There were, like, a couple of small videos that were recorded. Did you allow him to record it? Yeah. All right. Did you have conversations about what he could do with those recordings? Yeah. And what were those conversations about? Well, I told him when, like, we did it, like, don't send this around to people, like, this is, like, private. Yeah. Now, again, this is incredibly imprecise language for this. Why? Holy fuck. I was so happy listening to her talk. Oh my god. Anyway, okay. And what did he tell you? And then the judge intervenes. Now, I want to give you some perspective, okay, in case this judge ever seems mean, okay? I just want to give you perspective. If you read any cases like this, okay, the defendants are unhinged men that are crazy. It'll be like, this girl broke up with me, so I sent videos of me coming in her face to all of her family members, all of her coworkers. I posted them online on porn websites. The defendants are, or like, I recorded her, she didn't even know it, and then I started sending it to her new boyfriend. That's like the types of people that are normally defendants in these cases. So in terms of like what you're seeing in this case, and the judge, you'll watch the judge start to realize more and more of this, I'm a pretty atypical case, right? My stuff got posted against my will, against my consent, out into the public. I didn't want any of this posted. All of our videos were recorded consensually. We talked about sharing them beforehand, right? This is a very atypical case, and you'll see the judge. Okay, kind of talk about this. So, well, I told him when, like, we did it, like, don't send this around to people, like, this is, like, private, yeah? Also, keep in mind here, she doesn't mention whether or not I could send it to Melina, my wife. And then her lawyer asks, and what did he tell you? And then the judge interrupts for a moment. The judge says, why would you allow him to record you? And then she says, so we were talking about it like ahead of time, mentioned it like that could be something that was like hot, I guess. I don't know. I mentioned, what is it? Wanting to show it to this is so embarrassing to talk about. I'm so sorry. Give me a second. I remember I told him like, oh, when it came to like the sharing, like, is it like, sorry, I'm like, to show it to like the person that I was like currently in love with and stuff like that. He even expressed like, oh, what if that person like shares it around? And I was like, oh no, like, don't worry. Like, we'll make sure that it's like very limited. Like, it could just be my face. I trusted that he wouldn't send it around because we had so many conversations about consent and how I didn't want anybody else to know that we were sexual. You know, it was a stupid decision. Why would you say it was a stupid decision? That is putting the onus on you. Looking back at it, it was very dumb of me to do, but I was also, I believe, 20 around the time. You were 21. How do you not know your age? All of this is a matter of our records. You can check. I only had one partner before him, and I really just, like, I thought I could trust him. I thought, okay, this isn't going to spread around. He's not going to do anything like that. We literally talked about this for hours before, about consent and the importance, so I just thought that it was, like, safe, and that it would be okay, and that was dumb. Okay, so the reason why I liked hearing her talk about this so much was because, if I'm being totally honest, I don't remember, okay, 100%, technically I shouldn't say this, but at this point, okay. I don't remember 100% conversations that I have in person with every single person, but I remember the gist of them, and I know, like, how they tend to go, right? So if I'm talking to a girl, and I've said this before, I'm talking to a girl, and, you know, we're talking about recording stuff, and she says something like, oof, like, if this ever leaked, I don't know, man, I think it would be over for me. I would be so embarrassed. If somebody says something like that, I'm like, okay, we just won't record anything. This is not, it's not worth it. Or if you want to record, you can have it on your phone, you know? My recollection would have been at the time for Pxie was essentially what she's saying here. Like, don't publish it publicly. Don't send it to every fucking person you know. But it's like a relatively small thing, you know? I had my wife at the time. She had her boyfriend at the time. I'd shown her videos of me and other people. This is basically this is our kind of arrangement that we've spoken about. And here, whether it was due to the imprecision of your language or she was just stressed, she basically gives that same answer. And another huge issue here is that she labels her own decision-making as dumb. This is supposed to be my fault, not her making a dumb decision. So it's just a bad approach to this, in my opinion, but, you know, who am I? And then the judge says, apart from your encounter, had you ever seen anything on his, what do you call them, live streams or streams that was sexual in nature? She says, he did talk about, like, personal relationships before. So this is another thing. He was in an open relationship with his partner Melina at the time, and he would talk on stream about like the importance of like boundaries and consent, and you know how you have to like listen to your partners and, you know, be aware and smart about that stuff. So, and he also presents himself as like, you know, leftist, liberal, like cares about women's rights, thinks about those things are important, respecting women. So all that information I had at the time where I made that decision was, oh, this guy really respects women. He really cares about consent. He really, you know, he's very aware sexually about boundaries and stuff like that. Like, there's no way that he's going to betray all those values. Like, that's kind of a mean thing to do such a thing. So that's what my impression was at the time. So she's trying like really hard to play this stupid PR game of, oh, he's a leftist liberal who betrayed his values. This is for the Substack, honey, not for when you're trying to give accurate testimony and deposition. But again, what do I know? Her attorney asks, had he ever made any commentaries prior to your encounter about indicating that the posting of explicit materials is one of the worst things that you could do to someone? Her response, he definitely said that on the stream. I don't think that was before the encounter, but that was after the encounter. He had live streams where, you know, these topics would come up because he's a political live streamer. So the topic would come up about, oh, what do you think about consent and doing this or that? And he did indicate on one of those live streams that that's one of the worst things you could possibly do to someone. My lawyer objects, objection, Your Honor, hearsay, and then, oh no, and then... An objection is when the lawyer believes that a question is asked that the jury shouldn't have the right to know the answer to, right? Objection, they shouldn't ask this question because this is not relevant. There could be a million reasons why you call an objection. When you call an objection, The judge is the one that decides whether or not the jury shall have access to this record or that the question shall be asked. The judge is supposed to make that call. So my lawyer calls for an objection. Objection, Your Honor, hearsay. And then Pxie goes, it's not hearsay. And then the judge interrupts her and says, I will decide if it's hearsay. It's overruled. Meaning the objection was overruled. He allowed the question to stand. But she tried to answer. Oh, no. Anyway. By the way, this is what all the Kiwi farmers and legal and all these retarded Kiwi farmer lawyers, all of these people thought that this was going to be me, by the way. But anyway. Her lawyer. So, Miss Doe, at some point, was any of the content from your encounter, sexual encounter with Mr. Bunnell, circulated to your knowledge? And then Pxie says, like publicly, or... And then her lawyer says, well, how? Was it ever circulated in any fashion? And then she says, I sent it to my previous partner, and that was it. Now, I will say, I never knew this. I'd never known about this. I had no idea, no clue about it. Now, being honest, I will say, well, yeah, I mean, we talked about this. This was kind of like the agreement. I would figure that if there are guys she's hooking up with or whatever, that maybe she would, that maybe she would share it. Like, because that's what we recorded some of these for. I had no idea, though, until this hearing at this point in time, okay? And then her lawyer says, was there consent from Mr. Bunnell? And then the judge interrupts again. And the judge is like, what do you mean? I'm sorry, I misunderstood what your answer was. And then Pxie goes, my previous partner, my previous boyfriend, the one that earlier I mentioned when I did the encounter with Mr. Bunnell, I was like, oh, can I send it to the person that I'm like currently, in love with? That would be the only person who would like, and then the judge interrupts again and he says, so did you send it or did he send it? And then Pxie goes, I sent it and I showed it to my previous partner. And then the judge says, and how did you get a copy of this? And Pxie says, he sent it to my phone. And the judge says, he sent a video to your phone? And then Pxie says, yes. And then the judge says, and then you forwarded it? And then Pxie says, yes. And the judge says, okay. And then her lawyer says, was that with Mr. Bunnell's consent? And then she says, yes. We never talked about it. Again, I didn't even know this. And she says, yes. Not only that, and I don't know if these will ever come up in the future court filings, because I don't even know if this is even a real fucking case anymore. But one of the things that Pxie would tell me about her boyfriend a lot was that he got really jealous. The reason why we stopped hooking up or sexting at all, we only hooked up one time. The reason why we stopped sexting is because she said that her ex would get like really jealous and stuff. So I had no idea that this guy who is super jealous of her hookups, and I don't even know if this guy hates me or not, has, 3 videos of us. Like, I don't know that. But, hey, it's all Gucci, whatever. And then she says yes, and then her lawyer says, all right, did there come a time that Mr. Bunnell disseminated your video to any other individuals without your consent? She says yes. He asks, all right, and when did he do that? She says, he apparently did this on multiple occasions. Unfortunately, there's contention around the exact date when he sent it to Rose. I thought it was October 4th. She's lying. But it could have been 2022. They're saying it was April 4th, 2022, or something along the lines. I'm not sure. The judge says, well, back up a step. When did you first learn of him transmitting anything? And then she said, oh, I learned that on the day after Thanksgiving, November 28th of 2024. The judge says, okay, and how did you learn it? And she said, because one of the people that he sent it to decided to publish my video and the video of multiple other partners to a website called Kiwi Farms, and that website is known for also doxing and harassing people. And the judge said, and how did you learn of this? And Pxie says, because I started getting messages from a whole bunch of people and random strangers in DMs, and people started posting under my social media pictures of the video and then telling me oh, you just got exposed to oh, I hope you know this, but your Destiny video got leaked out. Oh my God, yeah. And the judge says, okay. Now a question, now I don't know what the judge is thinking here, but again, if you're not an idiot, the big question here is, wait a second, why aren't you suing the person who, now I'm not saying the judge is implying this at all, but the question I think any reasonable person, and this is what both lawyers told Pxie before she found this current law firm, why aren't you suing the person who published this video online? What? Why is that person not a party to this case? Hello? And she's fully admitting all of this as well, right? Now keep in mind, if this hearing feels rough so far, this is a direct examination. Direct examination is just your own lawyer asking you questions to get stuff on the record. This should all be good for you, okay? All of this should help you as much as possible. All right. The judge says, okay. Her lawyer says, so that was in November of, just totally inexcusable. She says, yes, no, sorry, 2024. Wait, why are we cuxing? Hello? Wait, everything looks good on my end. We're good? Okay. The judge says 2024, you said? Pxie says, yes, November 2024 is when I first found out that the video had been publicly disseminated. Her lawyer says, there's the who is Rose. Pxie says, I wish I could tell you. I wish I knew who she was. I don't even know if the defendant knows who she is exactly because it doesn't seem like they ever met in real life. According to, like, the messages online, it seems like she was a 19-year-old girl, but he never verified her age, to my understanding. So the hacker who took control of the account, or whatever, claims that she was 17 at the time they started sexting and corresponding. And that's kind of all I know about her. I just know he never actually met her, and we don't actually know her age. Now again, why isn't this person in court? Why aren't we suing anybody involved with this? Why do you seem to know so much information about this person, but you didn't name them as a party to the case? Kind of weird. Yeah, and that's kind of all I know about her. I just know that I never actually met her, and we don't actually know her age. Why does that matter here? This is, again, like you're just using the court... wait, hacked mic. Stuff is out of sync. Wait, is stuff fucked right now, or hello? Are we okay? Refresh if you desynced. Okay, refresh if you desynced. Her lawyer asks, as this issue has progressed, did you come to learn whether or not Mr. Bunnell had continued to share that explicit encounter without your consent? She said, yes. And what other occasions are you aware of that he shared it with other individuals without your consent? She says, after I spoke about this issue and what was happening, I found out that Abby MC apparently received a video of me in 2023. I got a couple of messages as well of people who said that they think that they received a video of me. One of those people said that they think that their sister received a video of me and that the sister recognized me from a video just a few months ago. But unfortunately, some of these people have deleted their accounts. Why the fuck did you not get affidavits and everything from these people before filing your suit? If you thought that these people were relevant, why would you not get affidavits? Why would you not get everything that you could about these people? But hey, you know, whatever. Andrew, objection, Your Honor. Lacks foundation, also contains hearsay testimony. Her lawyer responds, it goes to state of mind, Judge, and this hearsay is admissible in this type of hearing. The judge says, well, I'm not admitting it for the truth. It's just for the perception at the time. And when did you learn of the second distribution? She says, the Abby or the person who said the sister? The judge says the first of those. She says, it was after January 20th, after the Substack was posted. That's when I started receiving people, or a few months after that. Her lawyer says, after you initially found out, after Thanksgiving, that this video had been uploaded to Kiwi Farms, did you make efforts to contact Mr. Bunnell? She said, yeah, I basically, because I know that there was more than one video in that encounter, like I asked him if he sent anything more to other people. I was really paranoid, essentially, for the next few days that something else would come up that I wouldn't know about. He says, when was this conversation? The judge says, when was this conversation? Pxie says, it was the day of that I found out about the leaks. I texted him immediately. I was like, what's going on? Did you send this to anybody else? Like, how many other people are? Or is there anything else that I should be prepared for, basically? The judge says, this is in November of 2024. She says, yes. Her lawyer, when did Mr. Bunnell respond to you? Or what did Mr. Bunnell respond to you? Pxie says, he said something along the lines of, I'm so sorry, there's literally no excuse. I was fairly close to this person. If it makes you feel any better, literally no excuse. I'm so sorry. Her lawyer says, however, after that date, he continued disseminating. Pxie said, I will argue that, yes. What do you mean you will argue that? The answer is yes or no. My lawyer objection, calls for speculation. The judge says sustained as to form. Her lawyer says, okay. So that discussion took place in when? November 2024, correct? She says, yes, November 28th of 2024. How does she know that exact date? Whatever. He says, all right. And the other individual who says that their sister received it approximately how long before January 20th, 2025? She says they said a few months before. They said like 2 to 3 months before, something along those lines. Her lawyer asks, and even after disseminating it to Rose, he had continued disseminating it thereafter, correct? She says yes. He says, all right. Did at any time did Mr. Bunnell have a hyperlink to Kiwi Farms in the video? Andrew says objection, vague and ambiguous. The judge says overruled. You can answer. She says, by hyperlink, do you mean like sending his followers there? Or the lawyer says, correct. Pxie says, there was a Twitter post where he directly told everybody that they could still find the material on Kiwi Farms. So he did tell everybody, like, go to this website, find this material, basically. Now, just to be clear, and I hate how fucking disgusting she is. I hate how disgusting Pxie is. She's the grossest woman, the most disgusting, vile, putrid woman I've ever interacted with in my entire life, okay? My complaint was that everybody's making videos and complaining about all this shit, and my 29 videos, of which like 25 of these are just solo fucking jerk videos, are still hosted on Kiwi Farms. Everybody's talking about this. All my shit is so publicly out there. And her interpretation of that is he basically told everybody to go to Kiwi Farms and find out. I was like, okay, thank you. Thank you. That's exactly what I'm saying there. Thank you so much. Her lawyer says, when did he do that? She said he did that, I think, around February 20th. I'm not sure of the exact date, but I think it was around February. The judge says of 2025. She says yes. The judge says, now, prior to November 2024, had you maintained a relationship with him? She says, prior, yeah, we were friends. He had this live election stream for the election, and I was there. We collaborated in kind of the same projects with his community. Yeah, we were friends. Her lawyer asks, how has the dissemination of this video impacted you personally? She says there's various stages to this. When the video first came out, I basically could not sleep. I had a lot of trouble sleeping at night. I was super anxious all the time. I was just waiting for somebody to, like, tell my parents or my family what happened. I would be crying constantly. I was super depressed. I was in a really bad state of mind. And at the time, one of my friends was like, oh, maybe you should, like, try to seek legal justice because that seems to be, like, something that's, like, really big on your mind. So I tried doing that. And then I was told that there was no guarantee of Jane Doe's status and that if I didn't receive that, good luck. You know, people are going to harass my family potentially more or my, you know, just as a clear thing, I think this is a fucking lie. I think she asked a friend or something about this because the Jane Doe status is literally baked into the federal statute that she's suing me under. So I don't know who would have told her this. Now, I don't know if she'll say this in the hearing, but the one thing that she was told by 2 separate law firms, and I know this, but I only know this because of the leaked DMs between her and Aaron, because she hasn't turned over any of those to me because she's not giving me anything in discovery, which is interesting. But in the leaked DMs to Aaron, she mentions 2 different law firms told her that she didn't have a case against me, that she should be suing the guy that leaked the videos. Just saying. So she continues. So and I'm not saying that this was right or okay, but that's what my mindset was at the time. The original plan was basically for me to commit suicide and schedule a note for after I died, detailing what Stephen had done and hoping that everybody would forever know what he did and be able to stay away from him and be able to be more wary and cautious. And it was only after essentially being on like suicide watch with my friends. I'm very lucky to have the friends that I have that were constantly checking on me every day and making sure I was okay and, you know, basically convincing me, hey, don't do anything rash. At least do your best legally first, and then if that doesn't work out, you can figure it out later. But just try this option first before the life-ending one. And that's when I decided, okay, I'm going to try my best to go that route first and see what I can handle and everything. So just to be clear, this is extortion. I don't know if no one had told her this, but this is extortion. You can't come to me and say, I need you to give me $1 million or I'm going to kill myself and post a note about you to embarrass and humiliate you. That is textbook extortion in all 50 states. That is extortion. You can't do this. Well, I mean, I guess you can. I guess you tried. Also, just to be clear, because a lot of people are bringing up Aaron in chat, I think it's gross that Aaron was able to get back into every community and nobody cared or seemed to have any questions about it. And I think her political views are disgusting. That being said, okay, maybe I'm just a simp loser retard. Personally, I don't actually think Aaron interpersonally did anything wrong here besides trusting President Sunday with all the DMs. I do think Aaron was just looking out for everybody in the situation. I don't think that she was trying to be malicious. I think she was genuinely looking out for Pxie as much as she could. Just her sharing DMs with President Sunday was just so fucking stupid. But that's my assumption of it. But anyway, hold on a sec. Okay. Her lawyer asks, Do you still receive, or are you still the subject of derogatory posts on social media as a result of this encounter with Mr. Bonnell? Now, also, just a couple things, and I think all these DMs are public now. I really don't like the way that Pxie talks about suicidality with her friends. In my opinion, it is incredibly contrived and carefully crafted, because in every suicide message she types to somebody, she always types, I think I'm going to kill myself, but don't worry, I'm not going to do it like now. It's probably going to be a month or two from now. And I feel like when she's saying that, she's saying it so that she can't be Brady acted or whatever, so that she can't get interned or committed for 3 days or whatever at some suicide watch place. She's always saying, like, I'm going to kill myself, but don't worry, I'm not going to do it now. I'll wait until the holidays end. I've seen like 3 different messages where she types something. She's done it once to Aaron. She did it, I think, twice to, she did it twice with Kyla. She might have done it with me once. I don't know if she did that. I'm not suicidal right now. That, in my mind, that's crazy. Also, oh God, I need to do like MDMA for one of these streams. I wish I could cry right now. Okay, pretend I have tears streaming down my face. Okay, my best friend killed himself when I was 21 years old. That was a pretty fucked up moment in my life. Okay, laid down in some train tracks and let a train run over him and died. His name was Christopher Aguirre. It was Malvern, Iowa. You can read the story online. So it's kind of crazy to me. All right, if I was a crying person, okay, I would be invoking that trauma right now, and I would be saying, "Oh my God, my best friend killed himself," and she was using the same language. Okay. Oh, and Reckful killed himself too. He was a friend of mine. But you know, just saying. It's hard for me to read. Okay. All right. Kaya, sit. Jesus. No, I'm just kidding. Okay. All right. He said, do you still receive, or are you still the subject of derogatory posts on social media as a result of this encounter with Mr. Bonnell? She said, oh, absolutely. Although I will say that most of it is from Mr. Bonnell's community now. Not very good. He said, how has this impacted you? She says, I have like thousands of people online believing that I was not serious about suicide. I have thousands of people online say that I was like a liar and that I am lying about this case continuously, even though I would argue the opposite actually holds true. Obviously, the general feelings like depression and anxiety, and I fear like going outside, but I think the biggest one, like, I don't know, I still struggle with the suicidal thoughts sometimes. I'm getting help mentally, professionally. But what I see is like thousands of people basically claiming that I'm lying about how I feel and that I wasn't actually serious. Like, yeah, there is a little part of my brain that is like, maybe I should end it and stop the pain that I feel and just show everybody that I wasn't lying and that I am, and this is not okay. Oh, and then she starts crying at this point. And then her lawyer says, do you need a second? Would you like some water? She says, yeah, please, 1 sec. He says, we'll get you some water, Miss Doe. Are you okay to continue? She says, can I have like 1 minute, please? Her lawyer says, Your Honor, would you mind giving her a break? The judge says, you can take a 5-minute break. She says, thank you. And then, okay. Miss Doe, her lawyer, do you feel ready to proceed? She says, yeah. Did you have to have discussion with your family about the uploading of this video? She said, yeah. He said, what was this conversation like? She said, oh my gosh, I just got out of it. I'm like, okay, sorry, And then the judge said, well, the judge interrupts and he says, well, let me ask you this question. Do they know about your relationship with the defendant? I think she says yes here. It says no audible response. Maybe yes or kind of. And then the judge says, okay, and who all did other people know? And then Pxie says, there should have only been 2 people who should have known. My ex-boyfriend and Steven's ex-wife, Melina. And to be clear, I told him he could tell her, but I didn't say anything about showing her anything. But those were the only 2 people who should have. Now, big issue here. What? So earlier she said just not to send the video around. Then she said nobody should know about anything. Now she's saying, well, I told him that Melina could know, but Melina couldn't see the video. Remember, this is the core claim of really, truly all 4 of your acts, your civil causes of action here, especially your federal claim. How are you unclear about what the agreement or the arrangement is that you're coming to court to testify about? This is the most important. And also, keep in mind as well here, excuse me, you're saying that you and me recorded sexual material and I said that your boyfriend could look at it, but my wife couldn't? In what world would that ever be an arrangement? Bro, Melina would kill me. There's no world, and I would never make that arrangement because I would feel cucked. Like, hold on, we're recording something where you can show this to whoever you want, and I can't even show it to my own wife? Wait, what? So dumb. What a dumb, horrible answer, but whatever. The judge says, now, let me ask you this question. You said you originally met him through online. Have you yourself had an online profile before? She said, at the first time I just started, I transferred universities, and it was a very big change. I didn't have a lot of friends in my new university, so I was like, okay, I have a camera, I have a computer, maybe I can try making friends this way, online, just live streaming, talking, see who I connect with. The judge says, when was this? She says, it was around 2019 or 2020, so it was around 2019 or 2020, around there. Again, I don't know how she doesn't have all the dates for this memorized. This is your court case. Do you not care about any of this? Is this a joke to you? The judge says, okay, and what university were you going to at the time? She said, I was going to Fordham University, but I just transferred to University of Florida, Gators. The judge says, so you began engaging in online social media accounts, things of that nature? She says, yeah, I just kind of leaned into politics. I was like, these are the topics that I care about, that I think are important. And then people were like, those are important, or no, you're so wrong about this. The judge says, did you ever introduce your personal life into any of your videos or your posts? She says, not really, no. I mean, the only thing, Destiny, quick cube, pee break, shut up. The witness, she says, not really, no. I mean, the only thing I would talk about that would be somewhat personal would be, things relating to mental health and the importance of it, and how, I think it's not something talked about enough in society, but I wouldn't tell people this is the university I'm going to, or these are, my name. I made sure I would not say that. Keep it super private because I know that with that information, people can do a lot of damage. Wait, hold on one sec. Okay. Then the judge says, I was going to ask you that question, actually. Did you post or submit things under your own name or under a moniker? She says, generally speaking, if not every single, all social media accounts, Pxie, I didn't want people, to know my real name, period. The judge says, okay, so back to counsel's question about you telling your family about your encounter with the defendant. She said, yeah, so basically, the way that conversation went is my dad told me that he was disappointed at me. He was disappointed. And then I kind of had to stop him there and tell him, please don't say anything else because I promise you there's nothing that you can say that I haven't already thought of or have told myself. So yeah, that's kind of how the conversation went. After that, my parents softened a little bit because I think they could see that I was not in the best mental state. But yeah, it was really embarrassing. Her lawyer... minor sidestep, I guess, for life advice. Especially if you're listening to me and you're younger, make sure that you DM. Stop! Not an appropriate joke. Very inappropriate. If you're younger, if you ever get into some fucked up shit and you're actually facing some real trouble, either legal or interpersonal or some crazy shit, and you're worried that your parents are gonna get mad at you, I promise you, unless your parents are actual sociopaths, okay? I promise you, Mom and dad will always be there to help you or stick up for you to keep you safe first and foremost. And it's always better to go to family or mom or dad rather than assume that they're not going to be on your side and then risk fucking your whole life up. Okay? Your parents will always thank you. If it's a super huge thing, they might not even punish you for it because they're happy enough that you came to them. Just saying, always keep that in the back of your mind. Don't hide life-destroying shit from your parents. Even if you think they're going to judge you or whatever, assuming they're normal human parents that love you and care about you, which they do, even if they're mean sometimes, or unless they're sociopaths, they will help you, okay? Don't always keep that in mind, okay? All right. But not if you murder somebody. Yeah, Tyler Robinson went to his parents and they sold him out. So I guess if you murder somebody, don't tell them. I'm just kidding. Okay. All right. Her lawyer asks, going back to an earlier topic, you mentioned kiwi farms. After Mr. Bennell directed his followers to the content back on kiwi farms, fuck you, OC, fuck you, okay? Are you aware of how many people viewed it or how many people accessed that site? My lawyer said, objection, calls for speculation. Her lawyer says, if she knows. The court says, I'll sustain it based on lack of foundation. Her lawyer says, all right. Her lawyer said, did you at any time go back to Kiwi Farms to determine whether or not how many views that video had obtained in a certain period of time? My lawyer says, the same objection, Your Honor. And then the judge says, you haven't established a predicate. The judge says, when were you first alerted that there might have been a posting or an uploading on What is Kiwi Farms? Like another Instagram kind of thing. I think when it says establish your predicate, so you can't just ask a question without any kind of like lead up to establishing why the question is relevant or whatever. Like you have to like set up the question first. I believe. I don't know all the objection rules. You can go Civ Pro is a class that everybody hates for a reason. Go look all this up on your own time, okay? All right. Pxie OC is opposing counsel also, sorry. The opposition's lawyers, opposing counsel is OC, sorry. Pxie says, the witness, it's like a website, it's an online forum. The judge says, okay. Pxie says, basically, a bunch of people anonymously post there. Usually they have threads targeting individuals to like harass and dox them. And Destiny has his own thread of people there posting negative information about him. The judge says, okay. And then Pxie continues to yap. And he was aware that this website existed, and he was also aware there was a thread about him. And the only reason I bring that up is because it's insane to me that, that you have like a dedicated group of people who just want to harm you or are trying to find out every single bit of your personal life, and that you're just disseminating out pornographic content of others without consent, privately, whatever, knowing that these group of people exist out there. But that's a side note. I first found out on November 28th, where basically the same day, essentially, that's when everybody was like, oh, Kiwi Farms has your stuff, Kiwi Farms has your stuff, Kiwi Farms has your stuff. The judge says, so it was contemporaneous with you finding out the first time? She says, yes. The judge says, got it. She says, I do want to note that the website gained so much traction that it crashed repeatedly, to my understanding, to my knowledge. By the way, that crash was because of my blowjob videos, my gay videos, not because of anything with Pxie, but, nobody even really knew about that outside of like a few unhinged people on Kiwi Farms, but that's okay. Andrew says, move to strike, Your Honor, Lex Foundation. Her lawyer asks, how is it that you know that? She says, I know that because the owner of the website made a public posting saying Destiny's BJ video is getting so many views that the website crashed. Not the gay one, not the one with Pxie. I don't know. She tries to make it sound like that, but whatever. He says, where was that? Well, I should say the bi one because I'm not gay. Okay. He says, where was that posted? She says that was posted on Twitter. The judge says, so you found out about the Kiwi Farms connection on November 28th? She says, yeah. Then her lawyer asks, when was a posting by the owner of the site? She says, about it being crashed. And then he says, yes. And then she says, it was a few days after. I can't recall the exact date. I just remember seeing it a few days after and being like, oh my God, everybody knows. She knows that this was not about her. I think Noel's tweet, somebody can go find it. I think Josh's tweet might even specifically reference that it was the gay video, but okay, whatever. Her lawyer asks, are you familiar with a Google Drive that Mr. Bunnell has with this explicit video of your encounter with him? My lawyer objects, Lex Foundation. The judge overrules it. She said, so I know he had, and I know Abby said that she had received an explicit material of me through the Google Drive. I know he had a Google Drive, or apparently he would upload a bunch of other people's, including him, but like pornographic content without their... The judge says, how do you know this? She says, I know this because the leaker... Well, I know this for a couple of reasons. I know this because the leaker posted messages where Destiny is sending Google Drive links to Rose, to the girl. So there's messages of Destiny being like, oh, if you want to see this video, here's a Drive link, here's a link, here's a link. And the judge says, and you got that from who, Rose? She says, the person who took control of Rose's account leaked all the messages between Destiny and her, and that's included there. First of all, it's not all the messages, but okay. I also know this because multiple women afterwards came out and told me, oh, I received pornographic content about other people, and now I realize that content was probably without consent using these links. And I know that because Destiny himself has stated, and at that time, I thought anything he uploaded there was with the consent of other people, but now I realize that's not the case. Early on, he sent me a Google Drive link or mentioned one, so those are the ways that I found out. So like all of this is just like not related to any of this at all, but okay. The judge says, so when is the first time you found out about the Google Drive link? Also, this is really bad too, because it wasn't until afterwards when I went back and I was reading the messages, I didn't send any video Pixies through a Google Drive link. It was just a media attachment on Discord. So this whole legal theory that they were flirting with here is all bunk, but they bring it up a lot because they want, obviously, to lean into this as much as they can. When is the first time you found out about the Google Drive link? The judge asks. She says, I can't remember the exact date because he deleted all of our messages, but I do remember that he sent me one of Melina, like a file with Melina, through the Google Drive, and I assumed like, okay, like, he's sending me this, whatever. And the judge says, and when was that? And she says, when was that? That was before, I think, our first sexual encounter, but I honestly can't recall the exact date. That was before, you think it was before the sexual encounter? You don't know? Remember this answer. It's going to be brought up later. And then her lawyer asks, and Melina was who? And then she says, his ex-wife. And then the judge interrupts again. The judge's interruptions. I'm almost crying. Not even joking. I'm almost crying as the judge is asking questions because I'm like, thank God, like I'm not crazy. And I didn't come into this hearing like, because the whole internet and all of Kiwi Farms and all these fake lawyer fucks, the esports Batmans, the legal mindsets were all saying one thing. And I'm like, there's no way, right? These people are crazy, right? And they are. So the judge stops and he's like, so he sent you a video of his ex-wife before your encounter with him? And she says, from my memory and recollection. And then the judge said, didn't that give you pause then to allow him to tape you? And she says, no, because I thought, like, Melina, the way that she was also described to me, and my understanding of her, was that her and Steven were in a super sexually liberated relationship, that they were, like, super open with each other, and that they were super open about sex, and, you know, that they didn't really, like, care about that stuff, but that they were also very respectful about boundaries because open relationships can't work without the proper set of boundaries and understanding. Is this like a slut-shaming argument against Melina? I don't even know what the fuck we're going with here, but okay. And the judge said, and you got this information from who? And she says, Steven. And the judge says, okay. And then she says, so I was, and again, like, the only person I was with before Steven was my former boyfriend. So I just thought, like, oh, you know, this is just something I don't have a lot of knowledge on, but he seems very experienced and understanding. And we've had so many of these conversations about consent. She loves using this word over and over. Consent, consent, consent. It's like we're on the internet, and every time you use consent, it makes everything like rape, basically. But she uses the word so much. Like, yeah, I was just under that impression that everything was going to be consensual. Then her lawyer asks, did Mr. Bonnell ever state to you that he was going to make efforts to take down the videos from Kiwi Farms? She said, yeah. He said that he was hired a legal firm to aid him in that, yeah. And then her lawyer asks, to your knowledge, do the videos still exist on Kiwi Farms? She said, I believe so. And then her lawyer says, okay, and during the course of the pendency of this case, has Mr. Bonnell dodged you by attempting to publish your name on any of his streams? She said, yes. And she said yes. And he said, and how did he do that? She said, I think it was the 19th of February. Even though he never, even in real life, he did not call me by my real name. He called me Pxie because that's an effort that I went to when it came to my streaming friends or my content creator friends, like referred to me as Pxie, Pxie, Pxie. That's how rarely I use my name, even whenever he referred to me for the first time ever as my real name. Now, this is true. However, the protective order wasn't issued until the 20th of February. Again, if you want to sue me in big boy court, okay, well, let's not be Pxie and Destiny. We'll be our real names. Like, yeah, well, you're filing a federal public case against me, sure. But now once the protective order got filed, it's like, oh, okay, then I won't do this, I guess, since we shouldn't do it, yeah. The judge said, and when was this? She said, this was, I believe, February 19th and 20th. Like he uploaded another video in another channel called Last Night on Destiny or whatever on the 20th, but I believe his live stream was the 19th. Her lawyer says, okay, the video that was shared of you, did it include a depiction of intimate sexual content that you were involved in? She said, yes. Wait, sorry, can you repeat that question? He said, yes. Did the video that was shared by Mr. Bonnell of you and him involve intimate sexual contact? She said, yes. He said, all right, you indicated that it was also shared with Miss Mac without, Miss Abby Mac, MC, I think, without your consent. Oh, he's saying like Mick or Mac. Do you know if Abby Mac was outside the state of Florida? Yeah, she lives outside the state of Florida. Do you know what state she lives in? I can't remember off the top of my head right now. They don't want to say, by the way, because they're helping her dodge subpoena, by the way. She still is continuing to dodge and hasn't been deposed, hasn't given any testimony, continues to avoid us. But, okay. She said, yeah, I'm sure. I think she just moved out of Texas. That's why I'm not sure exactly what state. But we had conversations before where I know 100% that she's not in Florida. At the time that the video was shared with her by Mr. Bonnell, do you know she was living in Texas? I think so, because I think she was, but I can't say for sure. Andrew says, objection, calls for speculation, and it lacks relevance. Judge says, overruled. She doesn't know, bottom line is the answer. Her lawyer says, did you consent to the disclosure of the video at any time to Mr. Bonnell? She said, disclose, like Mr. Bonnell to send the video to other people? He said, correct. And then she said, no. So now her answer here is, before it was like, don't send it around. Before I could tell Melina about it, I guess, but not show her. And now it's like, no, cannot send it to anybody ever. Yeah, just having her give like separate different answers to this is just like crazy to me. I don't know how she doesn't have one super strict, like well-prepared understanding. Remember, this goes to the core of her federal claim against me. Is it still direct examination? Yes. Wait, do Catbox files not open in Europe? I can't open this. Somebody said apparently Noel had said gobbling cock about me, and that's why the website went down. So it was about the gay video, not the, yeah. Destiny, she was going to say not exactly. Oh, maybe. Maybe she was going to say not exactly, but instead she just said no. Maybe. Okay. Her lawyer asks, okay, I don't have any further questions at this time, Your Honor. Thank you very much. The judge says, thank you. Cross-exam? Andrew comes up. Thank you, Your Honor. My king, okay? Good morning, Miss Doe. Good morning. When you first started communicating with Mr. Bunnell online, the court said, since we don't have a reporter, introduce yourself for the microphone for me. Andrew says, I'm sorry, I'm Andrew Brettler. I represent the defendant, Stephen Bunnell, Burke Brettler, LLP, in Los Angeles. Andrew, Miss Doe, when you first started communicating with Mr. Bunnell online, your conversation turned sexual at a pretty early point in your relationship, correct? I don't think so. I think it was a couple of months. Maybe you guys have the messages. He deleted all of mine, so I can't say 100% for sure, but I don't think it was pretty quick. Just to be clear, I can't delete her messages. That is not true. I can go right now on Discord and look, her messages are all still there. I don't know why she lies about this several times. She lies over and over and over and over and over about this. I can bring up on Discord hold on. Well, I don't want to show anything because I don't know if there's like information that can't be published. But yeah, all of her messages are still here. So I don't know why she keeps saying this. I don't know why. I don't know why she says this. He deleted all mine, so I can't say 100% for sure, but I don't think it was pretty quick. Andrew says, on March 17th, 2020, at 5 o'clock in the morning, you sent a message to Mr. Bunnell stating, I took some videos with a guy. I can send you later if you're interested. Also, do you recall sending that message to Mr. Bunnell? I don't recall, but I'm going to assume that the message exists. And in response, Mr. Bunnell said, yes. At 5:01 a.m., you wrote, okay, I'll send them to you when I get home. Happy face. Heart. Do you recall sending that message? I don't recall, but I assume it exists. You don't recall sending him a video of somebody else? I recall my former boyfriend, who I would refer to as that guy, didn't want me to send videos of us, like, experimenting and stuff like that. I can't verify, like, the specificity of the messages because I don't have those messages. Wait, so her boyfriend didn't give? Wait, how did I miss this? Or maybe I wasn't... By the way, they haven't made him available for deposition either because we've asked for him because I would like to depose him and ask him questions about, like, just curious. Did you know that Pxie was sending videos of you guys, banging to famous streamers online? Do you have any idea about that? Did she talk to you about this? She talk about sending, I'm just curious. Interesting that she says here that he didn't consent to that. You didn't miss this before. You mentioned it after the court. Oh, maybe. Okay. Maybe it's been wiped from my mind. I can't verify like the specificity of the messages because I don't have those messages. The judge says, do you remember sending him of a video of some sexual encounter? Pxie says, yes. Andrew said, and I'm also getting there, Your Honor. Mr. Bunnell offered to send you videos of him and his wife if you wanted them. Do you recall that? Yes. Do you recall responding at 5:03 a.m. on March 17th, 2020? I'm open to anything you want to send me. You know I'm a super curious person. I think he is asleep, so you might have to wait for my videos until tomorrow. Do you recall sending that message? Again, I can't say specifics, but I'll assume it exists. Yes. Do you recall asking Mr. Bunnell, is there any particular photo or position you'd want to see me in? I assume that message exists, but I'm a little confused about what this line of questioning, like, do you recall saying to Mr. Bunnell, I'm with my guy friend right now, I can probably get a photo of me sucking him off, if you think that would be hot. I assume that message exists, but I don't know if I'm overstepping my boundaries here or whatever. What does that have to do with Mr. Bunnell sending my video to other people that I didn't know? Miss Doe, do you recall on January 3rd of this year, January 3rd of 2025, where you posted online, I have never sent videos of other people to Steven, ever. 1. I remember sending that to Dan Saltman in a private DM, and the context of that was Dan claiming that everybody in the sphere was non-consensually distributing materials of other people. So that was the context where I was thinking, like, no, the guy I had my former boyfriend's consent, the only one person I was with before, moved to strike as non-responsive. My question, Ms. Doe, was, do you recall texting or posting online on January 3rd at 10:37 p.m.? I have never sent videos of other people to Steven, ever. I remember messaging Dan privately. It's very different than a social media post. Yes? Yes. The answer is yes. Move to strike everything after yes. I don't know if this means she said more here and it's just not on the transcript. I don't remember if she said more here. The answer is yes. Move to strike everything after yes. That wasn't a true statement, was it, Miss Doe? No, it wasn't. And then the judge stops. And who is this character? Dan. What is his name? Dan Saltman is one of the best friends of Destiny, who's also a business partner with Destiny. They run a podcast together. He was going online claiming that everybody had done what Steven had done, and that's when I messaged him. So you're responding to him? The judge asks. If it's stricken, it's not their Destiny. Okay. Sometimes she yaps a lot, and then my lawyer, Andrew, will just say, so the answer is this, strike everything from the record after. So I don't know if that shows up in here now. I just thought those moments were very funny. I wish I could do that in a debate so much. This hearing was one of the things, and that lying about Hitler book was like, dude, court, where you have to ask and answer like in a straight line of questions and you can't pivot or divert or anything else. Oh my God, it's so nice. So the judge stops and asks, so you're responding to him? Dan Saltman. Pxie says, because I saw him on a podcast or on a stream, and he was making those claims. And this was the 3rd, right? January 3rd? Can you confirm that? She asks Andrew. No? Okay. My lawyer doesn't have to give her anything, doesn't have to help her at all. And she's like trying to get help on the stand because she's... So the judge asks, what was the date of the communication? And so the judge can ask questions, okay? So the judge asks my lawyer, what was the date of the communication? And Andrew says, January 3rd, 2025, Your Honor. It's funny, it's actually a little bit like poker. You can ask a player, if you want to put them all in, what's your stack? What's your count? Sometimes you'll ask players to see how they answer. You can get information about how nervous they are, but the player doesn't have to actually answer you. You can ask, like, did you fold? You have 2 cards? Did you bet? How many chips you got? The player doesn't have to answer at all. You can ask the dealer, could I get a count of his chips? And the dealer can count them for you and tell you. So it's kind of funny. There's like a similar setup here, but. So Pxie then continues. Yeah. So this was still before I made my Substack, basically. I was still in a state of denial between when I first found out and between when I made my Substack. I was trying to downplay what happened as much as possible, claimed that no, like everyone's just confused, everyone's just wrong. The judge says, let me ask you this question. Prior to this point, had you already been engaging online with others about your problem? She says, yes. The judge says, how often? She says, to the people who would randomly send me DMs being like, this is you, I would try my best to deny it. The judge says, no, but on an online platform, in other words, on a more public platform. She says, oh, on a more public platform? No, I did not. I did not claim, make statements about it being me or anything like that. By the way, that's also a lie because she was posting about it in Spicy Chat and maybe other Discords, but I know at the very least in Chud Logic's Discord, she was posting comments about it there. But the judge says, okay. Andrew says, my lawyer, going back in time, do you remember when you messaged Mr. Bunnell in March of 2020? Did you get the video? I'm also open to any videos you want to send me in general. LOL. Objection, her lawyer says. Asked and answered. Relevance. The judge says overruled. Andrew says, as I said before, Pxie says, as I said before, I assume those messages exist. Andrew says, okay, and do you recall telling Mr. Bunnell after he expressed that he enjoyed watching your video, yeah, it felt really good when he was being dominant and making sure I was a good girl for him. And then her lawyer, objection, Your Honor, relevance. There's no doubt that this took place. The judge says, overruled. She says, yeah. Andrew says, do you recall responding that way? She says, I assume it exists. He says, okay. And do you recall telling Mr. Bunnell also around that time, that's the whole thing, but I have another video of me fucking in lingerie that won't send through here. And no worries, we can talk more about it tomorrow. She says, I assume it exists. He says, do you recall asking Mr. Bunnell also in March of 2019, do you have anywhere else you think the videos could send to? She says, I assume it exists. He said, my lawyer asks, you inquired whether or not he could send the videos to you via Instagram. Do you recall that? She says, yes. He asks, it was your idea, Miss Doe, to make a sexually explicit video with Mr. Bunnell, correct? She says, that I'm not completely sure of. He asks, on March 19th, 2020 at 5:12 in the morning, and then the judge stops again. The judge says, I thought you said that he suggested it. Did I misunderstand that? She says, no, I'm pretty, well, again, like, I don't have the messages. That's a lie. I don't have the messages, so it's pretty hard for me to recall exactly. I remember him sending me something of Melina's earlier on, and remember earlier she said, I don't know if it was Melina before or after we hooked up. Now she's saying it was before, okay? I remember him sending me something of Melina's earlier on, and me assuming, oh, like, do you want to make videos together as a response to that? But again, I don't have the messages. I can't recall perfectly, but that's, and then the judge says, it's possible that you brought up the topic of recording with him. And she says, it's possible. And the judge says, okay. Then my lawyer says, not only is it possible, but on March 19th, 2020, at 5:12 in the morning, do you recall sending a message to Mr. Bunnell? It's going to be so nice when you do, question mark. Would you want to make some videos together? And Mr. Bunnell responding at 5:13, 1 minute later, if you want to, yeah, for sure. Do you remember that exchange? She said, yeah. And I remember before that was when he sent the stuff about Melina. But yeah, continue. And then Andrew says, so does that impact your testimony at all? That it was Mr. Bunnell's idea to make the video? Or do you now realize that you were the one that first raised the idea about making videos together? She says, what I claimed was that he sent me Melina's stuff. And as a response to that, I was like, oh, do you want to make stuff together? Because I thought him sending Melina's stuff was like, oh yeah, like, you know, he's into recording stuff. My question was, does it refresh your recollection that it was your idea to actually suggest making a video with Mr. Bunnell? I'm trying to think of how to phrase this in a way that makes sense. If I'm like, all right, I'll use this analogy. If I have like a cup of water and I drink it and I'm like, oh my God, you know, water is really cool. I love water. You know, water's awesome. And you go, oh, hey, do you want some water? Because you keep, you know, you sat here talking about water. Is it, okay, I'm not sure how to phrase this. The way that the judge interrupts her and he says, well, is it safe to say that you're not sure whether it was your idea or his initially? And she goes, yeah, because, and the judge says, that's fine. Next question. Andrew asks, the next question is, do you recall sending Mr. Bunnell a subsequent message saying, do you want to take videos when we do stuff together? I think I'd really like one of you coming in me. She said, I assume that's true. And then the judge interrupts and goes, so this is in March 2020 or 2019? And then my lawyer responds, 2020, Your Honor. And the judge says, okay. So then the first video that you had with him is sometime thereafter, I take it? And then Pxie says, yes. And the judge says, okay. And then my lawyer asks, do you recall after the video was published on Kiwi Farms that you told Mr. Bunnell that it's not clear that it's your face or anything like that and that you are 100% denying that it's you in the video? Hold on. Okay. Do you recall, okay, where were we? Okay, so then the first video that you had with him is sometime thereafter, I take it, the judge asks. She said yes. The judge says, okay. Then my lawyer asks Mr. Bretler, oh, yeah. Oh, wait. Do you recall if the video was published? Okay, that you denied, 100% denying you. And then Pxie says, oh, yeah, I was in complete denial. I was like, oh, well, maybe people can't see my face. My face is clear as day in that video. And then she says, do you recall telling Mr. And then the judge interrupts again. And the judge says, when did you tell him this? I'm sorry, when was this exchange? And Pxie says, I believe immediately after I was getting messages from everybody telling me that I was in the video. And the judge says, so sometime in November or early December? And she says, yeah. And then Andrew answers, November 29th, Your Honor, the day after she claims to have identified the video. And then he asks, do you recall, Ms. Doe, that following the publication of the video on Kiwi Farms, that you created what's called a Substack page where you talked about this matter? And then she says, yes. And then the judge says, what's a Substack page? And then Pxie says Substack is basically like a platform. It's kind of a social media platform where people post more like longer articles or statements or things of, I would even argue, more of an academic nature than other platforms. The judge says, so it's not like for videos, it's for more articles or writings? She says, yes, yes. And he says, okay, and is this public? She says, yes. And he says, and do you create a profile just like you would for Instagram or something? She says, yes. And then my lawyer asks, and on your Substack page, you notified the world, or all of your followers at least, that have access to your Substack page about the existence of this video, correct? Somebody in chat said, looks like the judge is trying to make a timeline of events with dates. Yes. So one of the issues that I brought up like 8 months ago, there are these two concepts of like proximate harm and foreseeability, right? Let's say, for instance, that I leave a firearm. Let's say that I have a loaded firearm and I leave it in my house, okay? And let's say that a very close personal friend of mine, Empath Chan, okay, finds this gun, goes out and shoots and murders a bunch of people, okay? If that were to happen, I'm not liable at all for that. It's my house. Sure, it's a loaded gun, but like this is not like, that's, foreseeability is zero. That's not, I didn't do this. And the proximate harm is she's the one that was the closest to causing that particular harm, right? That's on her completely. Now, let's say in another world, let's say that I load a firearm, okay, and I go to visit my girlfriend who's currently in daycare, okay, because that's how young I love them, all right? And let's say that I drop this gun off, I just like put it in the middle of the floor while all these like 7-year-olds are playing with each other, and let's say that I walk away, right? Now in that case, I think proximate harm might be on the child that picks up the gun and shoots somebody, okay, but for foreseeability there, well, it should be highly foreseeable that if I leave a loaded gun in front of a bunch of kids, that like somebody's gonna pick up the gun and do something horrible with it and kill people. So like I could be held more liable there. So foreseeability, proximate cause, these like types of concepts are really important when it comes to establishing fault or when it comes to establishing liability for particular damages. And one of my biggest claims from the very beginning of this case is basically all of the liability, I would argue, obviously in court, all of the liability is on Solo. This guy took these videos and posted them online. Nobody else did but him. He's the guy who would be, in terms of like harm or damages, it's all on him, right? You have a very, very, very hard time using a foreseeability argument here, and we'll get into this in the later part of this, trying to say that, well, hold on, you should know that if you send a video to somebody, it could leak, because wait a second, if that's going to be your argument that I should have foreseen that, then you should have foreseen that when you and me recorded stuff, you know? So it's a very, very, very difficult dance that they have to play here with arguments of foreseeability related to me, because they're going to have to try to make an argument that makes me liable that doesn't also spill over onto her. That's a very challenging thing to do, I would think, in a case like this. Now, that's assuming that they win, that the jury finds me liable and everything else, but that's a very, very difficult thing they're trying to walk. But that's also why, in my opinion, I think that's why they obfuscate on the timelines, on who leaked what, on who had permission for what, is because they're just trying to make all of it sound the same. That's why in Pxie's any proof of that, but they also haven't turned over any discovery related to her. Thanks, by the way. I think that Lauren Hayden was the one trying to float these arguments to her, but I don't think that that is a... some people are saying it's lagging. I see no lag on my end at all, and usually I'll see drop frames if it's fucking up on my end, so... Oh, no, wait, it is a little bit on Kick. So actually, hold on. Kick is reconnecting. Hold on. Wait, Kick's not down, is it? Wait, people are putting F in YouTube chat. Oh shit, it's down there too. Fuck. Wait, are we here on YouTube? Hello? Oh. Fuck. Did I say my YouTube stream or is it totally fucked? Hello, hello? Yeah, YouTube is good. Wait, did it totally drop my thing? Do I have to do like a whole new stream or is it good? It survived. Oh my god, it survived. Amazing. Okay. Okay. I'm in the French part of Switzerland. So they don't believe in internet. Down in these parts. Wait, this one. Okay, I'm sorry. I'm killing my kick for now. Because I don't think I have the bandwidth for both. Are we alive? I'm chilling. I'm waiting. Hold on. Are we okay? Okay. Dude, I almost broke my controller. Okay, I have like 2 big ass batteries now for my laptop so I can play games while I'm flying. I was trying to kill Simon on the flight, and it's just a laptop that's not plugged in is like a little bit laggy, and like having the shit lag while I'm also trying to parry, I was like ready to break my shit. I was gonna be so fucking triggered. What are you doing in Europe? Tomorrow I have a debate with Mohammed Hijab in the great country of Bong at Oxford. I also like to visit. I like to visit my European brothers so that I can make fun of Americans so much more, because you guys just have, people in America have no idea how crazy good you guys have it. You have no clue. Americans are so fucking spoiled. And they talk about like unaffordable housing and everything. Meanwhile, you go to like any European place of living and it's like radiator. You're like, where's the thermostat? And they're like, thermo what? Is that an American word? And I'm like, the thing that changes the temperature. And they're like, sorry, we have a fire that burns inside of pipes that kind of heats up part of the apartment sometimes. I'm like, what? And they're like, your country has no history. And it's like, in Europe, the history is their like living facilities. Okay, every building is like 150 years old. You know when they say like, in America, your stuff falls down like that, it's because our shit is new and we build it so that we can take it down and put up new shit if we want to. Their stuff is old and it sucks, okay? It sucks. All of their bathrooms, all of their amenities, it's like all these old knobs and shit that you have to twist and turn, and it like nothing is like, God, everything in America is just Kino. It's just Kino, all right? Absolute Kino. The worst is when you're in the UK and you have to wash your hands. It's one of the reasons why these guys burn so many more calories is because there's 2 taps. There's the one for cold water, because that's the safe drinking water, and there's one with hot water, but there's probably a bunch of like dead rat corpses in the hot water tank. So you have to turn both on at the same time, so you don't burn your hands. You have to have the cold water here to protect you from the hot water, but you need to get the hot water to your hands. So you have to do like this. So you go, you got to do like this when you wash your hands. So you like soap a little bit, and then you do to get like the cold and hot mixed. And it's crazy, okay? Okay, I'm sorry. Anyway, I'm back. The judge says, let me back up. When did you first create the Substack profile? Oh, wait. No, I'm sorry. Hold on. Andrew, On your Substack page, you notified the world, or all of your followers at least, that have access to your Substack page about the existence of this video, correct? She says, I think notified kind of implies that they realized for the first time, and I don't think that's true at all. The judge says, let me back up. When did you first create the Substack profile? And she says, honestly, I can't remember, because I remember I created one a long time ago, because I was like, oh, maybe I want to start writing articles. I'll have it. But I'm not sure if that's the same account I created for this posting, so I can't really remember when. The judge says, okay. And can one make it public, or is it private, or is it automatically public? She says, you can actually do both. You can create private articles, save them in drafts, or you can publicize them. The judge says, and the one that relates to this after November 28th, did you make it public or private? Now, again, I can't speak to the judge's state of mind, okay? I'm not trying to put thoughts in his head, but my guess here is when somebody files one of these cases and they file as a Jane Doe, it's humiliating, okay? You don't want the whole world to know that there's porn images of you or porn videos of you on the internet. Most plaintiffs in these cases file under a Jane Doe because they don't want that shit to be out there publicly. And having somebody file as a Jane Doe, but also be making a ton of public writings attached to their entire online persona and attached to like videos of them and images of their face, that's incredibly strange, okay? It's a very weird thing to do. It's not very typical in these cases. So Pxie says, I made it public. And the judge says, okay. Andrew says, it was before you filed your lawsuit that you made it public, correct? She said, yeah, but I do want to point out, I feel like the claim, like made it public, it was already public information. Like what happened that day was two people. I'll start here. I found out that my best friend, and then Andrew says, Your Honor, there's no question pending. And the judge says, well, I'll let her answer. Go ahead. Andrew says, okay. Pxie yaps. I found out that my best friend had betrayed me and was sending my private messages with her regarding the situation to random other people online. And then those people, who I did not know, decided to make YouTube videos with those messages. And those YouTube videos were of defamatory nature. They claimed that I took hush money and that I was extorting Stephen and that I do not care about other victims. They were gaining tens of thousands of videos, or tens of thousands of views. At this point, on top of the YouTube videos, previous to me publishing the Substack, accounts with tens of thousands, if not hundreds of thousands of followers were publicly making fun of me on Twitter. They were, Pxie, ew, your sex tape got leaked, that's quite the L. A whole bunch of stuff. So it was after the combination of having these accounts, making fun of me over the tape, and then having the YouTube videos that were gaining tens of thousands of views with my private messages lying about me, that I felt compelled to publish my Substack and clarify that no, I didn't take hush money. I was not extorting Stephen, and I do care about other victims. So that's why I take issue with the whole idea of, you publicized it because it was already public. People were already talking about it. I just said the truth and defended myself. So as a thing here, Pxie is lying about this because in President Sunday's video, you can see in their leaked DMs that 7 days at least prior to her publishing the Substack, she already had that full Substack written out. Now, in the operative complaint and in her original complaint, operative means the currently active one or the first one, whatever. In her original complaint and the amended complaint, and in statements she's made publicly, Pxie keeps claiming that she had to publish this Substack publicly because of all the other videos that had went live about her. But if you look at the leaked DMs in President Sunday's video, she had already had that full Substack written out a week earlier. She was always planning on publishing it. That's a lie that she tells in this hearing, and it's a lie that she tells in multiple court filings. The judge says, were you concerned, though, that by doing that, you were only making the story even bigger? Because then more people would try to find your video. So now remember, the judge is asking this because in most of these cases, the plaintiffs are not trying to publicize every single thing about them online. That's crazy. Most women find this stuff humiliating. They don't want everybody to know who they are, that their face is like attached to things, that like it's just very atypical. She says, I thought about that, and that's why I specifically put two things. I put nudes because I thought people were less likely to search up the video, but then on top of that, it was already in motion. What do you mean, put nudes? She says, instead of saying my video, a video, I said, oh, he disseminated nudes. And then, well, I see. In other words, you didn't put images of yourself, you referred to them as that. Okay. She said, yes, I said the nudes. The judge says, okay. And she says, and then also, I never mentioned what websites they were hosted on specifically. So I just said, he sent it online. Now keep in mind, in her complaint and the amended complaint, she does list all of the fucking websites. Good one, Chief. Nice. And also at this point in time, the machine was already running. I guess is the best way I can say it. This is also a lie. Most people were just talking about the gay videos that had leaked of me, and that's it. Nobody was talking about nobody outside of like KF even really knew that Pxie was involved. It was just, but whatever, she can lie here, I guess. The videos were gaining so much traction, and people were just repeating what was on those videos, that I felt like, okay, either I can make a statement now and defend myself before everybody believes these lies, or I can stay quiet and do nothing and hope it will go away, but it's not going away. It's been 2 months. It's been 2 months since the original leaks. People are still talking about it. People are still harassing me, and now I have these videos gaining like thousands of views, and either I can do my best to protect what little I have left, or I can stay quiet and then the judge interrupts and says, did you make an effort to, after November, before you did your own Substack, did you make an effort to take down the videos off the Kiwi thing? Is there a process where you can communicate with Kiwi to take down things that are improper? She said, so I was in communication with Steven beforehand, and he told me that he had hired a legal firm who was dealing with that stuff. So in my head, I was like, okay. The judge said, he was doing it. She said, yes, Steven was dealing with the Kiwi Farm legal team. When it came to other websites, and I had a conversation with Steven about this, I was submitting basically Google request forms and like forms to those websites as well, personally, just trying to be like, oh no, this non-consensual revenge porn, please take it down. So I was making those efforts beforehand as well. And the judge says, thank you. This is hurting my back. Hold on. Ugh. Okay. Charged pickles. And since you bring it up, okay, now my lawyer is asking again. And since you brought it up, Ms. Doe, about the idea of extortion, do you recall messaging Mr. Bonnell? I feel that whatever I ask you to cover will be too high a price, and then I'm even going to feel worse over it. Now, it's interesting, by the way, that she says yes here, because this is a message that she deleted from our DMs that they have not been able to reproduce. By the way, they keep accusing me of spoliation. That's her engaging in spoliation, because she deleted this message right before she sent me a letter on the 20th, or the 23rd is when I got it, I think, for which was a request for the preservation of evidence, basically notifying me, hey, there's going to be a lawsuit. You better not delete shit because you're going to be in trouble for it. She deleted shit and then sent me that letter. So it's funny that this is the only message she seems to be able to recall, but it's the one message in our DMs, I think. Well, there might have been more she deleted and I just don't know about it. Yeah, and then her lawyer says, objection, Your Honor. There's no extortion reference in the record, so I object to the form. Andrew, my lawyer, says, she opened the door, Your Honor. The judge says, I didn't understand your question anyway, so I'll sustain. Ask another one. Andrew says, I'll withdraw it for now. I'll come back. Andrew says, in addition to your Substack, and then the judge says, it's got to follow all the particulars in fairness. And then Andrew says, I understand, Your Honor, and I will be more clear. The judge says, okay. Andrew, in addition to your Substack, did you create a what's called Give Send Go account to promote your lawsuit against Mr. Bonnell? She says, a Go Send Go? He says, correct. She says, I made a Give Send Go. He said, Give Send Go. She said, yeah. And Andrew says, okay. And then the judge says, how do you spell that? Andrew says, Give, G-I-V-E, Send, S-E-N-D, Go, G-O. And then Andrew says, and Give Send Go is similar to a GoFundMe page, correct? She said, yes. And he said, and the purpose of you creating this Give Send Go page was to raise money to pursue a legal claim against Mr. Bonnell, correct? Yes. And on your Give Send Go page, you linked to your Substack post in which you described your version of the situation, correct? Yes. I'm going to try starting my stream on Kick again. Good luck. Okay. And to date, how much money have you raised from your Give Send Go page? Her lawyer, objection, Your Honor. It's outside the scope of the direct, and it's completely irrelevant to what we're talking about here today. The judge asks Andrew, how is it relevant? Andrew says, how is it relevant, Your Honor? She has been promoting this lawsuit and claiming that this has cost her so much money that other people are learning of the lawsuit from Mr. Bonnell when really she's hosting a fundraising page, trying to raise money, and continues to raise money. And I think it's important to see how much money has come in and when that money has come in. Judge says, it's relevant to ultimately damages, but for the purposes of an injunction hearing, which prong is it relevant to? Andrew says, I think it goes to irreparable harm, Your Honor. She's continuing to publicize the fact that the video exists, that she has a lawsuit that's pending against Mr. Bonnell in federal court, and she's publicizing that fact and trying to raise money for it. I'll move on if the court, and then the judge says, I'll sustain the objection as to the relevance of the amount, but not as to and then Andrew says, the existence of the site, and the judge says exactly. Now remember, the judge apparently found this irreparable harm claim relevant because this was one of the bases that they denied the preliminary injunction. Ultimately, what this hearing is about was denied in whole, right? And remember, what we're saying with irreparable harm here is if Pxie's saying he published bad videos of me, I need to raise money to make myself whole again, you can't really claim irreparable harm for the videos continuing to be published because if it was irreparable and you're saying publicly, I can be made whole again if I get money, well, that's kind of contradictory, It can't be both, Andrew, question. And when you created that Give, Send, Go page, Miss Doe, you created it using your legal name, didn't you? She said, no, I originally created it using my friend's name, Lauren, by the way. She allowed me to use it to be able to retrieve, originally it was created in my friend's name. And Andrew says, and it stated on the page that all proceeds would go to your legal name, which I'll leave off the record here. Is that correct? And she says, so what happened? And then he says, yes or no. She says, it's more complicated than just yes or no. He says, but it's a yes or no question. She said, no, it's not a yes or no, okay? What happened, I created the name under my friend's name, and then the website didn't tell me that it would do this, but they said, okay, put your name, like your bank account information, your name to receive the funds. But when I did that, it published it temporarily for a short time onto the page. And when I realized that, I contacted Give, Send, Go, and I was like, hey, I don't want my name on there. Like, can you change it? And then they adhered and they changed it. So it wasn't that I created this knowing my legal name was going to be attached to that. I was under the impression that it would just be my friend's name. And then the judge asks, because you weren't allowed to use a fake name like your online name? And then Pxie says, no, because it was for the bank account information, and that's when they put my legal name. And when I contacted them and I was like, hey, it's really important for me to not have my name on there, that's when they publicly changed the name back to my pseudonym. The judge said, okay. Andrew says, so you were allowed to use your pseudonym, correct? She said, not initially, no. It was only after I contacted the website and told them, hey, I didn't know that when I put my bank account information, that means that you would have, put my name there too. Please, can you change it to something else? And they were like, okay, we'll change it. So it wasn't originally an option for me. He said, my lawyer asks, you had a Blue Sky social account too, correct? She says, yes. And that's similar to an X or a Twitter account. Yes. And on Blue Sky Social, you publicized the fact that you would be suing Destiny in federal court and linked to your Substack and your Give, Send, Go page, correct? Yes. Yeah. And you did that before filing this lawsuit, correct? Yes. You've submitted hundreds of pages of evidence in this case. Do you have any evidence that Mr. Bennell transmitted your video, the video of you two, of you engaging in consensual sex after October of 2022? Abby MC's affidavit. Where is Abby MC? She lives outside of Florida. Has she produced a single document to demonstrate that the video was transmitted to her after the effective date of the federal statute under which you are suing Mr. Bonnell? Yeah, when she originally received the videos, she had messaged her friend shortly thereafter in 2023. Destiny sends me these videos thinking, I don't know who these girls are, but I do. It's Cherry and Pxie. He should really be more careful. And then the judge interrupts and says, and how do you know this? And Pxie says, I know this because Abby submitted the messages to us in evidence. And then Andrew asks, and there's not a single message attached to Abby MC's declaration that reflects that the transmission of the video was made after the effective date of the statute, correct? The judge says, do you know what the effective date of the statute is? Andrew says, let's say October of 2022. Somebody in chat just said, Destiny, your haters moved on from the case. They call you a pedophile now because the roasting is way more spicy and damaging their eyes. I understand that. Give it a month or two, and that's all I can say about that, okay? I can confidently say that every single claim made about that is incorrect, though. I'll just say that. Let's say October 2022. And then Pxie says, I believe that just timeline-wise, Abby didn't meet him until 2023, so it would not have been possible for her to send those messages before 2023. And then Andrew says, my question to you is, did you submit any evidence reflecting the transmission of a video after October of 2022 from any witness, Abby MC, or anyone else? Do you have any evidence at all, other than what you are speculating, that Mr. Bonnell transmitted your video after October of 2022? Her lawyer objects. Objection. Calls for legal conclusion. Andrew says, I'm asking if you have any evidence. That's all. The court says, overruled. So then Andrew asks again, then Pxie says, does the affidavit not count as evidence? She asks the judge. The judge says, it counts. And then she looks to Andrew and she says, so yes. And Andrew says, you have a statement. Do you have any documentation? She said, that's documentation. He says, do you have any evidence demonstrating a transmission of a video from Mr. Bonnell to any third party in the world after October of 2022? Her lawyer objects. Objection, Your Honor. Asked and answered. She's already said there's evidence, and there are statements, and they're part of the record. The judge says, sustained. She says, so, and then Andrew says, you don't have to answer. The next question. Mr. Brettler says, do you recall publishing on social media in April of this year that your goal here is to bankrupt Mr. Bonnell? She said, I don't think I said bankrupt. He said, okay, what word do you think you used? She said, can you just read me I can't remember what word just read me what I wrote supposedly, or, and then Andrew cuts her off and says, has there been any instance since this lawsuit has been filed where Mr. Bonnell, will you have any proof whatsoever that Mr. Bonnell has transmitted the video to any third party? Objection, judge asked and answered. Andrew says, no, it's a different question. Andrew says, since the lawsuit was filed, do you have any evidence that Mr. Bonnell has transmitted the video to any third person? Her lawyer objects again. Objection, Your Honor, asked and answered. It's the same question. Andrew says, it's not the same question. The judge says sustained on a different basis. And then my lawyer says, can I get some guidance? What's the basis for the objection? The judge says, I think she's already talked about that. So if you want to ask about a more specific thing, that's fine with me. For example, have you seen any transmission yourself or record of a transmission as opposed to what somebody's told you that evidence Mr. Bonnell sending a video after October of 2022? Have you seen anything? And then Pxie says, I'm sorry. I wasn't sure if he was going to ask that again. Okay. And then this message here, guys. I have not seen the video, him sending the video. So Andrew says, no further questions, Your Honor. So just to be clear, this is in June of this year. This would be, June is the 6th month, right? 4 months after the court case has been filed, 5 months after her Substack was posted, and maybe 8 months after it was posted online. They do not have a single piece of evidence showing me sending this video to fucking anybody. They have absolutely fucking nothing. None of this. Not the 15 women that came forward, nobody, because it has not fucking happened. All of this is fucking bullshit, okay? And they admit it right fucking here, okay? But this is one of the reasons why it's so annoying in all their motions when they keep saying, like, Discovery, we're so early in Discovery. We're still early in Discovery. No, we're not. We're done with Discovery. On my end, they haven't given me anything, but we're done with Discovery on my end. They're just mad because they haven't found, they don't have anything. They haven't found any evidence, and they keep, like, they're trying to dig through all of my shit, and they're mad. Okay. Redirect is, I think her lawyer can come up and ask her questions again, I believe. Her lawyer comes up. Mr. Brettler asked you about the goals of your lawsuit. He asked you whether the stated goal of your lawsuit is to bankrupt Mr. Bonnell. Why did you bring this lawsuit? I brought this lawsuit because I'm under the impression that Destiny is going to continue sending people's intimate images and pornographic content without consent. I think I have good reason to believe this. I think unless he faces some level of consequences, I think that's what he's going to keep doing. I think he thinks that he's invincible, legally and socially. He's talked multiple times about how he gets a competitive high from people trying to ruin his career and trying to ruin his life, and how he continues to seek that. And I honestly think that if nobody tries to bring him to justice, or if nobody tries to do something about his current actions, he's just going to do it for perpetuity. It's not going to end. It's never going to stop. By the way, I like how she sounds like literally spite-driven as fuck here, but okay. It's never going to stop. And I can't. The reason why I was originally suicidal was the idea that he would just continue to keep doing this. And I honestly, even if I lose, I don't think I could live with myself, thinking oh, I had a chance to stop him. I had a chance to do something to make sure this didn't happen again, to stop other women from being hurt, and I did nothing. You were asked about your GiveSendGo account. Are you personally wealthy? No. Can you afford to pay lawyers hundreds of dollars per hour to prosecute your case for you? No. That's crazy. Then who's paying for it? Who's paid for it up to this point? Because her legal fees are definitely in excess of $100K. And she only raised $50K on the Substack. What's she doing now? I don't think she works. She obviously doesn't stream or anything. What's she doing? Really makes you wonder. Andrew, Your Honor, I object. If they wouldn't let me go into how much money she's raised, her financial situation is completely irrelevant. The judge says overruled. Lawyer says she did. The judge said she can answer. She said no. And then her lawyer asks, as far as dissemination of the video after October 2022, there is a dispute as to whether or not the actual initial showing of the video occurred on October 4th, 2022 or April 10th, 2022. Are you aware of that? She said, yeah. And he said, okay, and could you explain that a little bit for the court's edification of what the dispute is about? Andrew says, objection, vague and ambiguous, and calls for a narrative. The judge says, how is she going to know this, sir? Lay a foundation for that. And then her lawyer says, okay, do you know when purportedly this video was shared with Rose? Now remember, in their own evidence, they have submitted European formatted dates, meaning some of the dates look like, some of the dates will look like 27/01/2022 or 2023, right? So unless they think there are 27 months in the year, it's clearly in day, month, year format, like very clearly and obviously. They're just pretending that it's like, they're pretending that there's some ambiguity here. There's not, it's bullshit, okay? She says, I don't know the exact date. I saw the leaked messages, and it seemed like the messages were, the way I read them, was October 4th, 2022. But their side is saying, oh no, the dates were reversed. It's European time or something. It was actually April 4th, 2022. So, and then the judge interrupts her and says April 10th. And she says, April 10th. So I don't really know, like, we would have to verify that information. And then her lawyer says, okay, but that information is information that you had gleaned from the actual posts themselves, correct? Yes. And you reviewed those posts, correct? Yes. By the way, the reason why this matters so much is because the law that she's suing me under wasn't active until October of 2022. It wasn't active in April of 2022. So that's why she has to run with this lie in the hopes that in the course of this case, she'll be able to find more evidence of me sending this video to anybody, because without it, her case is dead in the water. Because ignoring even if I would win on the merits or if we would dismiss it some other way, the fact of the matter is she can't even get this case off the ground because this law wasn't even operating when she's trying to claim when the initial video was sent. So that's why the date on this is so important, okay? And the timeline of October 4th is temporally close to the time that the videos were ultimately posted. She said, yes. That's not true. Wait, she says, sorry, can you repeat? I said, yes. You said temporally close to the times the videos were posted. He said, correct. She says, so you mean they were just close, right? He said, yes, we'll move on. Oh, this is not true. That timeline on October 4th, 2022 is temporally close to when the videos were ultimately posted. No, the videos were ultimately posted in 2024, November. So they're either lying here or her attorney is lost. Her attorneys don't do a great job on a lot of this. But also she has a bullshit case. So like it's hard to figure out, like, is she losing because she has bad lawyers, or is it because it's a bullshit case? It's kind of like a thing that is it's like a mutually exclusive thing. Like some people will complain that she had bad lawyers, and that's kind of true, but that's because no good lawyer would take this case because it's a bullshit case. They know it is. That's why the first two law firms that she contacted both told her, no, you don't have a case here. So the only lawyer she was ever going to find for this would be in my opinion, a law firm not qualified to do this level of litigation. Or at least this subject matter, or area of law, I guess, I don't know. So her lawyer says, yes, we'll move on. As far as your Substack, why did you post to Substack? She said, there's a variety of reasons why I decided to post to Substack. I posted the Substack because people were, and the videos were gaining traction, ones that contained blatant lies about me and were defamatory in nature. So, one, I felt like I had to defend myself and tell people the truth. Destiny, do you think she's lying to her lawyers? She could be. I don't know if she would or not. But then again, you could have asked me beforehand, and I would say Pxie's like the last person in the universe in my life that I would ever expect to do anything like this. So what the fuck do I know? Now everybody keeps accusing me of lying to my lawyers, so who knows, you know? Two, I did have to find a way to gain some level of legal funds if I wanted to pursue this legally because I was told that cases like this can get really expensive. And three, I wanted people to know the truth. I wanted people to know that what Stephen did to me and to other women was unacceptable, and I wanted to be the last person that he ever decided to do this to. And then the judge says, and remind me, when was this Substack created? She said, the Substack was created January 20th. Like, that's when the post was, when I posted the account. The judge said, and when did you file the lawsuit? She said, February 20th, I believe. And the judge says, about a month before the lawsuit? And she says, yes. And then her lawyer says, since the lawsuit, have you posted on Substack? No. Have you made any commentary on social media about this case since the inception of the lawsuit? Yes. And when was that? And what was it in reference to? I don't know why her lawyer would ask this question to get us on the record. I think it just makes her look bad, but okay. I don't remember all the exact dates of the social media posts. Also, you should know in advance what your lawyer's going to ask you about. Why don't you have these dates memorized? You are allowed to confer with your client about what you're going to, talk about beforehand. You can't coach the witness. You can't tell your client, answer like this, say this, do this. But like, she should know what the question is going to be. It's like she did no fucking prep whatsoever for any of this case. Like, it's all just a fucking big meme. I don't remember all the exact dates of the social media posts, but I remember when we were able to get the seals, I posted that online telling people like, hey, like, we're able to like seal some of these things. Like, you know, this is something that's possible for us to do. The reason why I did that was because there's a lot of women who are really scared of coming forward or to speak anything about relating to this. They're afraid of getting harassed. They're afraid of getting doxxed. So I thought that was very important information to post. When you posted, this is her lawyer, when you posted on Substack, did you use your real name or did you use your handle? She said, handle. He says, Mr. Bretler went through some intimate texts that you had with Mr. Bunnell leading up to your sexual encounter. At any time in any of your interactions with Mr. Bunnell, did you ever indicate in any way that it would be okay for him to share the video of you with anyone? No. Now, another question is, did he say the same for you? Because the answer to that is also no, by the way. He says, I don't have any further questions at this time. The judge says, all right, thank you, ma'am. You may step down. She says, thank you. Do you want to call the defendant? And then he says, I do. And the judge says, what I would rather do is have the defendant do the direct of the defendant so we can do it in a streamlined way. And then Andrew, my lawyer, says, we'll call the defendant, Mr. Bunnell, please. The clerk says, please state full name for the record and spell your last name for the record, please. And then I say, I'll do this in my own voice. My name is Stephen Bunnell II. My last name is Bonnell. Thereupon, Stephen K. Bunnell II, having been first duly sworn, was examined and testified as follows. Okay. I'm gonna use the restroom real quick and I'll be right back and then we'll read my... These guys watch way too much TV, okay? Jesus. I'll be right back, 1 sec. Okay. My lawyer, Andrew. Thank you, Mr. Bunnell. Do you go by any other names? Oh, they don't write like what happens in the courtroom, but it was really funny. So I stand up, and it's kind of weird because like every time I'm moving in this courtroom, there's like wind blowing, so my hair is slightly ruffling. The jacket, my very nice and expensive suit, I button as I stand up. It's kind of a little bit billowing behind me. And I cross the stand. Initially, their lawyer was standing there, and he drops his pen. I bend over very gracefully, and I go to pick it up and hand it to him. He tries to bend over, and his glasses fall off, and he's like shaking. And I'm like, did you drop your pen, Mr. Lage? And he's like, yeah. And then eventually he takes it, and then he tries to go back to his desk, but he goes to the wrong one because he's so starstruck. I'm just kidding. I'm making all this up. Okay. All right. Okay. Thank you, Mr. Bunnell. Do you go by any other names? No, my online handle is Destiny. Okay, and your online handle is Destiny. What? Who is Destiny? It's basically just me doing politics, philosophy, and video games. Okay, and could you explain to the court what you mean by doing politics, philosophy, and video games? Are you an online streamer? Correct. It's like YouTube videos, but you're posting them live, basically. And do you know the plaintiff in this case? Yes. How do you know the plaintiff? She reached out to me after we did a Twitch debate panel, maybe 5 years ago, I think in 2020, and we began chatting from there. And did you and the plaintiff develop an online friendship? Yes. At any point during your online friendship with plaintiff, did your conversations turn to a sexual nature? Yes. And at what point did they turn to a sexual nature? I don't recall exactly, pretty soon, maybe a few months after talking. And when you agreed that they turned into a sexual nature, how would you characterize that? What do you mean by the conversation turned sexual in nature? I think it began chatting, topics get a bit racier, maybe conversations about current partners and then sexual activity, and then it kind of tends in that direction. Was there a time when you would ask the plaintiff if she was interested in watching sexually explicit videos of you? Yes, I believe so. And was there a time when plaintiff asked you if you were interested in watching sexually explicit videos of her? Yes. And did you, in fact, exchange sexually explicit videos of each other with the plaintiff? Did you, and then I say of each other, as in me and her, or, and then he said, I asked a bad question. Did you exchange videos of yourself with plaintiff of a sexual nature? I say yes. This is my lawyer right now. Direct examination is my lawyer. And did she exchange videos of herself of a sexual nature with you? Yes. And was there ever any discussion prior to exchanging those videos on who you were allowed to send the videos to, or who she was allowed to send the videos to? Her lawyer objects. Your Honor, objection. Understanding that this is an injunction hearing and this is his witness, he's asking leading questions throughout the testimony, understanding the nature of the hearing. The judge says, I don't think they're leading. Overruled by Mr. Bretler. You can answer, Stephen. I say, I'm sorry, can you restate the question? Yes, was there a time when, the question was there ever any rules on who these videos could be shared with? And I said, if those conversations occurred, it would have been in person, and it would have been 5 years ago. I can't recall the specifics of those conversations. Do you recall telling the plaintiff that you intended to share the videos with your then fiance? Well, I can't recall that explicitly. It certainly would have come up. There's no world where my fiance would allow me to send videos of me and her to another person, and if I recorded something with the other person, to not share those videos with her, of course. He says, and do you recall the plaintiff telling you that her sexual partners would be seeing videos that you sent her? I said, again, I don't believe that we ever explicitly mentioned that. It probably would have been assumed based on our conversations. In 2022, did you come to meet someone online named Rose? I said, if by meet online, you mean digitally talk to each other? Yes, yeah. Before you get there, and then the judge stops and he says, before you get there, how long did you have any sexual relations with the plaintiff? And then I said, before I communicated with the party in 2022, I believe me and plaintiff, recorded in, let me understand. When you say any sexual relations, do you mean conversations or in real life? I asked for clarification. The judge says in real life. And then I say, I believe it's in the record, but I think the plaintiff, I want to say had just turned 21 when we did. So whatever math is, maybe 2021, I think, was the date on that. The judge says, and how long did you have a sexual relationship in real life with her? I said, in real life, we only met sexually one time. The judge said, okay. I say, we continued sexual conversations after, but we only had one sexual encounter. The judge says, you only had one encounter? I say, correct. He says, okay. Andrew says, yeah, let me back up. I did jump ahead a bit. Did you at some point decide to make videos, sexually explicit videos, with plaintiff? I said, with her? Yes, yeah. Okay, and was that in, approximately March of 2020? I say, that sounds right. Do you recall whose idea it was to make sexually explicit videos? I believe it was her suggestion. And did you arrange to meet with plaintiff in person to actually record a video together? I said, among other things, yes. And do you recall approximately when you met plaintiff to record the explicit video? I said, probably sometime after July of 2020. I don't recall the exact date. Would September 6, 2020 sound about right? That would, yeah. And during that meeting, firstly, where did you meet to record this video? I can't recall exactly where it was, but the place that we met initially, we met for dinner with two friends of mine. So it must have been in Florida, maybe Miami, I guess. Okay, and at the time, were you married? I said, I don't believe I was married. I think we were engaged to be married, though. My wife was from Europe, so... And then the judge says, your wife was a what? And I said, she was from Europe, Swedish. The judge said, oh, from Europe. I said, yep. He said, got it. I said, so the marriage process was a kind of convoluted for a bit, yeah. And then Andrew says, and did you, in fact, record a sexually explicit video with the plaintiff in September of 2020? Multiple, yes. And when you say multiple, what do these videos depict? Generally, we're not asking for details. I said, two of us engaged in a one-on-one sexual encounter. He said, and the encounter was entirely consensual? I said, yes. In early 2022, do you recall receiving an online message from a woman named Rose on Discord? Yes. When you say a woman named, that was her screen name, yes. Screen name Rose, and as best you can describe, who is Rose? As an online content creator, a lot of people reached out to me, kind of like plaintiff, through different platforms. This is a person who initially sent messages to me on Twitter. At the time it was called, now X. It was just a person who reached out who seemed to engage in some kind of sex work on X. And then she reached out to me and personally messaged me on that platform, and then we switched to Discord. And did Rose send you sexually explicit videos over Discord or any other online means? Yes. And did you send Rose sexually explicit videos of yourself? Yes. And was one of the videos that you shared with Rose a copy of the video that you made with plaintiff? Yes, although Rose didn't know who plaintiff was at that time. And did you not identify plaintiff in that video by her screen name, correct? By any name, no. And do you recall approximately the date that you transmitted the message to Rose containing the sexually explicit video? I believe it would have been April 9th or April 10th on 2022. Okay. And you understand that there has been some testimony today about whether or not the date format that's reflected in the transmission documents was in the European format or the United States format. I'm aware there's testimony concerning that, yes. And how are you certain that the transmission of the video took place in April, on April 9th or 10th, and not October 4th or so? I said, there are multiple ways. One is I have a backup of all of my messages with this person. A second way is that those messages still exist on Discord from that person in the date of April. The third way would be that when those logs are posted that are supposedly in contention, the timestamp at the bottom is written in a time zone that is European. And the fourth way would be that that same European time zone is referenced by, I believe, the person who posted those on the aforementioned website, Kiwi Farms. Question. And since April 9th, 2022, or let's say April 10th in 2022 in Europe at 1 o'clock in the morning, had you transmitted the video to Rose or to anyone else to the best of your knowledge? No. You're aware that plaintiff claims that approximately 15 witnesses contacted her, claiming to have evidence that you shared the video with them. Are you aware of this? I feel like I've seen conflicting statements about whether it's the video in the complaint or just other videos that aren't the subject of this complaint, but I've seen this, yeah. And have you sent the videos of yourself and the plaintiff to anyone apart from Rose? Let me stop there. To anyone apart from Rose. I said, maybe my ex-wife. We might have watched it in person, but it would have been after the videos were recorded, so. And then Andrew says, so none of those 15 potential witnesses that plaintiff has identified, however they've identified them, certainly not by name, you've never sent a video to any of those 15 people. I don't think so. I'm only uncomfortable because the 15 names haven't been made available to me. So say, for instance, my ex-wife was one of those 15, then in 2020 after we recorded, maybe, but to my knowledge, no, to the best of my knowledge. Now keep in mind, because they think that this is all a fucking game or whatever, they've never handed any of these names over to us. They're supposed to. Federal Rules of Civil Procedure, evidence handling, they're supposed to, but they've never made any of that available to us. So it could be that like, if Pxie was like one of those 15 people, then like, oh, well, fuck me, I guess. You got me, LOL trapped, but yeah. And then Andrew says, apart from your ex-wife, and then the judge says, how do you know though? And then I ask, how do I know what? And the judge says that you didn't send the videos to others. And I said, yeah, do you want me to explain that? And the judge says, yes. So I said, so after plaintiff made her public acknowledgement that she was going to file the lawsuit against me, I became aware that I had an obligation to preserve evidence for this case. So the first thing I did was online platforms allow you to request a copy of all of the messages that you sent, I think as a result of the GDPR in Europe. And once I made that request from all the platforms that I chatted on, I did a search through all of my messages to see if I had sent either the Google Drive link or that video, or if there were references to that video from anybody else that I messaged, and I couldn't find any references to it at all. The court, at the time that you sent the video, had you met this person, Rose? I said, no, I had not. The judge says, okay, so prior to that, had you sent sexual related videos of others to other people? I said, yeah, plaintiff would be one of them, yeah. And the judge said, all right, so this wasn't the, I don't know if I'm still talking or we're back and forth. I try never to interrupt the judge on that, but I say, well, let me be very clear. I'm so sorry. For sexual videos of other people, every sexual video that I send is involving me. So there might be another person in the video, but it's not just videos of others. Oh, for like half of you guys that are like normies and not Coomer online people, this might seem irrelevant, but one thing that I really don't like is a lot of people, Pxie included, keep trying to make it sound like I'm sending like just nudes of her or videos of her or other people to other people. Like every single thing that I've ever sent or shared with people, it's always of me. Like there might be another person, but it's my stuff. I'm only saying this because like some people maybe it seems the same, but to others it's like one is like substantially weirder. Like why are you sending just videos that another person to another person? That's kind of weird. But the other is like, well, obviously I'm only sending content that involves me, right? But okay. The judge says, right. In other words, of yes, sexual videos that you created. I say yes, and the judge says you sent them to other people before. I said yes. And when you do that, do you normally get consent from somebody or not get consent? And I said, so I would say that we generally have conversations at the time of the recording. People will express varying levels of comfort about material existing. If somebody's very uncomfortable, then we typically just won't record anything. Other people have experience recording stuff. I would say generally, if asked, maybe I could reproduce some of these conversations. I could go back and check, but usually the conversation would be like, hey, well, if you send it to anybody, just make sure it doesn't leak, haha. It's usually that kind of conversation. The judge says, at the time that you sent the April 9th video, that you're saying is April 9th, you knew it was a video of you and the plaintiff. I said, yes. And the judge said, and why didn't you communicate with the plaintiff that you were intending to do that? And I said, we both, or I won't speak for the plaintiff. I just have a lot of videos that I've recorded with people in the past who've also recorded videos of me. And I would argue it's kind of a norm that we just kind of trade stuff around, basically. The judge says, so you thought you had some kind of implied consent. Is that what you're saying? Funnily enough, the judge is the one that first brings this term up. And I say, yeah, basically. If they sent me videos of them and other people, I've sent myself videos with other people. I don't believe in any of the conversations I've had, for instance, with plaintiff. I don't think there was ever an explicit ask. I don't believe she ever asked me. I don't believe she asked me at the time if she could send it to her boyfriend at the time. But I wouldn't have objected because my understanding was basically that that's what we're doing this for. Yeah. And the judge said, I see. And then did you consider redacting the image of her face? Did that come up in your mind? And I said, it didn't at the time. I'm not the best at like video editing per se. I'm like a presenter, so that would have been beyond my technical hurdle, I guess. The judge says, but you're aware that you can do that. And I said, yeah. I would say just on my personal level, if I was at the point where I was trying to redact parts of a video, I would be uncomfortable sending the video at all because there are always other ways of identifying people, whether through an identifying mark or something. So in this case, when you sent the April 9th video, you weren't concerned about that? No, the person at the time had already shared explicit material with me. I have never had anybody leak a bunch of my private explicit material before. This other person was also kind of like a sex worker person. Usually they're pretty clear about that stuff. Like, it doesn't just happen. It would ruin their business, so ... Okay. And then my lawyer asks me, Andrew's back to asking questions. Would you say, Mr. Bonnell, that it's common among your community or your fans to trade sexually explicit material with each other? I say, I would say it's common in certain circles. He says, in what circles? I say, I would say it's common in certain circles. My community can be quite broad, so I wouldn't generalize everybody that way, but there are groups of people who trade a lot. So everybody that I believe is referenced in this case traded multiple explicit material back and forth. Would plaintiff be in that circle? I know for a fact that plaintiff has sent me videos with at least one person and offered with at least others, but I don't know. I don't have copies of those videos anymore, so I can't go back and check if it was always the same person. I don't recall that. And there was testimony about a woman receiving your video named Abby MC. Do you recall that testimony? I recall that declaration, yes. And the testimony today about the fact that Miss MC Abby MC testified in her declaration that she received your video after October of 2022. Do you have any response to that? So again, as I stated earlier, I made a copy of all my online conversations. When that person initially referenced me sending them explicit material, I went back and I checked my archive of the conversations that we had with each other. And when we had a back and forth, the conversation was pertaining to a pair of videos that were never at all relating to plaintiff. I know the date she's referencing. I have my messages from that day. If plaintiffs request the discovery, I can provide those messages. But yeah, it was not the video involving plaintiff. You have never sent the video involving plaintiff to anyone after October of 2022, correct? No. Or correct, yeah. Double negative. One of the questions that I wanted to ask you today was, what steps did you take after plaintiff alerted you to the fact that her video or your videos had been published online? What steps did you take to prevent the dissemination of that video? So, unfortunately, being a public figure, once something is out there, the way you deal with it is you have to be very careful because there's a thing called the Streisand effect, whereby aggressively going after material, you end up publicizing it even more. So I was in collaboration with plaintiff to figure out, how do you want me to report these? Do I make any of this public? The steps that I took were generally emailing websites using a combination of, a DMCA request for one, which is a Digital Rights Act saying, I have the copyright of this video, please take it down. And then I had an assistant working, sending an email to Kiwi Farms, letting them know that this was revenge porn posted without my consent. I don't believe either of those two circumstances were helpful, but this is why I was pursuing. I had another litigation firm in New York that I was hoping to get an injunction or something that would allow me to come with a stronger tool. And tell me about that. You hired a firm in New York to do what? Well, initially, the goal was to unmask and uncover the person who publicly published all the material and potentially to explore going after Kiwi Farms because the owner of that website was knowingly hosting material that he knew was a revenge porn of me and then publicizing it, making it available to everybody. Andrew said, give me one moment, Your Honor. Your Honor, I will reserve the remainder of my time for redirect. Thank you, and then cross-examination. Oh, so Andrew revisits his notes, sees if there's anything else I wanted to ask. He doesn't find anything, so he says, okay. So now this is cross, so her lawyer is coming up to ask me questions. So her lawyer comes up. You're aware that you're opposing the court issuing the order to Kiwi Farms to take down the videos of you and Miss Doe, correct? Yes. It seems to kind of fly in the face of your stated intent to want that video off the internet, correct, sir? No. No? You think those positions are consistent with one another, correct? Absolutely. Okay, why? My understanding is that a court order would only remove the videos temporarily. The videos could just be reposted. I don't believe the court order could make any statements about future behavior. I saw a ton of other explicit material that was posted on that website and across the internet, and none of that material was requested to be taken down at all. If anything, I believe that just those videos being taken down might even exacerbate public postings of plaintiff's own video because people would see that she's the only one being removed. And I don't even know if you're going to I don't even know if you're going to issue court orders to non-parties to cases. Although I really wish that some other parties were involved in this case. By the way, all of this was the foundational rationale for why the judge dismissed their court orders. Because Kiwi Farms is a non-party to the case, and because they weren't really wanting to issue a court order, they were issuing an injunction that was disguised as a court order. And they're not a party to this case. An injunction would have been an improper remedy for what they were looking for, and they didn't even really phrase it well. So, get smacked down, okay? Her lawyer says, that other party that you wish was involved in the case is somebody that you had contacted, correct? Can you remind me at what point in time this transcript? This was in June, like June 3rd, okay? So this was months ago, 4 months ago, I think. 4 or 5 months ago almost. So her lawyer asks me, that other party that you wish was involved in this case is somebody you had contacted, correct? Rose? I said, potentially. He said, okay, are you aware that the operator of Kiwi Farms is an individual by the name of Noel, or goes by the handle of Noel? I said, is his online name? Yes. Okay. And then he says, may I publish, Your Honor? Sure. And then he tries to DM ambush me. I think he has stuff on like a screen. What do you call it? A projector or whatever. Then he asked, do you see that on your screen? I said, it's kind of cut off. The judge says, the zoom is on the top button. There you go. He says, can you see it now, sir? And I say, okay, correct. And he says, okay. So he has so many dumb lines of questioning. Oh my God. He said, okay, so you disagree with the statement from the operator of Kiwi Farms that you had made no effort for attorneys to have them take down the video? And I said, I don't contest that statement. There are other parties besides attorneys that could contact him to take the video down, but, and then he says, but you indicated that you had hired a firm to do so during your testimony here today. Did you not, sir? And I said, yes, but I testified that the person that contacted Kiwi Farms was my assistant, not my law firm. The law firm that I retained had a lot of experience with Kiwi Farms and didn't think it would be a good idea to pursue that without an actual case. And then he says, so instead of using legal avenues, you sent your assistant to do it instead, even though you hired this New York law firm, correct? Andrew says, objection, argumentative. The judge said, overruled. I said, I'm sorry, could you restate the question? He said, sure. And then the judge says, the question is, you used an assistant, your personal assistant of yours, to do this as opposed to hiring a law firm. And I say, I don't like the phrasing opposed to. I did use my assistant initially, yes, because the legal process is slow, unfortunately, and this is a pressing issue. So I contacted using the means I had available to me initially, and then was pursuing a legal case in the back of that. And then her lawyer says, okay, in the legal case in the back of that, did you file any motions or file any pleadings to have Kiwi Farms take down this video at any time? And I said, we hadn't even been able to file the case yet before plaintiff made a public statement to file a case against me. Public statement? Well, have you filed anything against Kiwi Farms? I said, not yet, no. And he said, okay. And then the judge asks me, did you not tell the plaintiff when she first contacted you that you would do that? What did you tell the plaintiff when she first contacted you? And then I said, so if requested, I could produce an exact copy of those messages, but I believe it was something along the lines of, I am in contact with law firms and I'm trying to get basically somebody to pursue this case so that I can get a strong, basically an injunction to get this material removed and it would not be published on the internet. And the judge said, okay, and did you in fact do that? And I said, did I do what? The judge said, what you told her, did you do that? And I said, yeah. There were a couple of law firms that I went through initially that were kind of uncomfortable with the subject matter of the case. And then eventually I was referred to a really good law firm in New York. And then we had basically finished and were ready to file an anonymous suit against that process was there. But then plaintiff filed her lawsuit. And the law firm in New York typically does plaintiff work and not defense work. And so it's kind of an awkward maneuvering of that situation, if that makes sense. The judge says, okay. And then her lawyer asks me, so it would be fair to say that you, as of today's date, have not filed an injunction to take down the videos involving you and Pxie, correct? I said, correct. He said, all right. There was a lot. I think he shovels his papers at this point, and then he moves on to his next points. All right. There was a lot of questioning of Miss Doe about your interactions prior to your sexual encounter and what the parameters of that were going to be, correct? You heard that testimony? I said, I heard testimony that we had a lot of conversations about consent broadly, about what our sexual encounter would be. I believe we did discuss that, yeah. He said, all right, I'm going to show you a text message between you and her from February 26, 2020 at 11:20 p.m. and ask if you recognize this. Do you see it, sir? I said, yes. I'll say it's not a text message. It's a Discord message, but I understand, yes. And he says, okay. And in this is Miss Doe telling you what the parameters that she's expecting of your sexual encounter and your ability to discuss it or disseminate information about that sexual encounter with third parties. And I said, I'm sorry, could you restate the question? I said, sure. And then the judge intervenes. He says, what was your understanding of what this message was about? And I said, yeah. So the reason why I'm uncomfortable answering is this conversation was, I believe, occurring at a time when there were people publicly fighting over who had hooked up with who. And this message basically had to do with, does anybody know that we've hooked up, or did anybody know that we had a sexual encounter? This isn't about explicitly transmitting material or anything like that. This is just, does anybody in our community know that we hooked up before or had a sexual encounter before? So one of the things that they're trying to do is they're trying to say that Pxie me, typically I used to do this with every girl. Now I think I just don't. I don't mess with streamers, YouTubers, or internet people. Fuck that. Sexually. But the agreement, Pxie was always like, don't tell anybody we've hooked up because she doesn't want it to like undermine her online cred or whatever. But that's all that was. It had nothing to do with like, trading any material with anybody. Obviously I couldn't send this to somebody in our communities because obviously then people would know. But yeah, this idea that she keeps trying to go back to this, well, we said don't tell everybody that we hooked up, so that means you also couldn't have sent any of our stuff to anybody ever. It's like, well, that's not really the same thing. But yeah, they keep trying to carry this legal theory, or I don't know, whatever. Oh, and also she was fighting with Lav at the time, right? Okay. So he says, well, sir, you see here where it says, don't worry, I totally trust you. And you've been very clear with how seriously you take consent. And I also feel that you've been very honest with me, so I trust you and your words. What is that in reference to, sir? And I said, a reference to whether or not I had been gossiping about us having hooked up before. Well, what does consent have to do with that? Well, whether or not you would consent to me telling somebody we hooked up before. Okay, so she's not consenting to you telling people about hooking up before. You think she's consenting implicitly or giving you implied consent to share, intimate videos of her with you or with third parties? I said, I don't believe that the person who I contacted, they had no idea who the plaintiff was. I didn't identify the plaintiff in any way, size, shape, or form. This was 3 years ago, so apparently that person didn't say anything about that at the time, and nobody at the time had known that we hooked up. So insofar as me maintaining our, anonymity about our sexual encounter, that seemed to be true, as far as I was aware. And I said, to the best of my knowledge, when I messaged her, and I believe that was true. Prior to sharing the sexually explicit video of you and Miss Doe with Rose, did you contact Miss Doe and ask her for consent prior to sharing it? If we had a conversation, it would have been in person when we recorded it. Okay, no subsequent conversation? Not that I'm aware of, no. You were still in contact with her, though, at the time that you sent the video to Rose. You were in contact with Miss Doe still, correct? I'm not entirely sure. We were still friends on Discord, but there were times where she might have been, I think she took like a medical absence to, I don't know if she was pursuing school or relationships, so we weren't really talking as regularly. But I don't recall the exact dates of that. But you made no effort to tell her, look, I'm thinking of sharing your video with this third party. Are you okay with it? Correct. And you took no efforts to hide her identity on that video, did you? I had no reason to believe the other person knew who the person was. I didn't identify her at all, so. Well, was Jane Doe's face visible? Oh, wait, hold on. Cox? Are we alive? Are we dead? Okay. Well, was Jane Doe's face visible in the video? Yes, and Jane Doe had appeared on your podcast previously on your stream, quite a while ago. Okay, and her face was visible at the time? Yes. In your streaming, have you ever, to a different line of questioning, in your streaming, have you ever stated to your audience that posting explicit materials is one of the worst things you can do to an individual? I said it would have been with more qualifiers, but probably. And have you ever stated that there's no secrets in the streaming world? I imagine so, yes. After this lawsuit was filed, have you ever made the statement while streaming, after today, her public reputation will be finished? After the lawsuit was filed? Correct. Wait, I'm not cuxing, am I? Wait, okay, give me 1 minute to let everything settle out. Okay, chill. We're good? Okay. He asks me, there's this cross-examination, so her attorney's talking to me. After this lawsuit was filed, have you ever made the statement while streaming, after today, her public reputation will be finished? I said, after the lawsuit was filed? He said, correct. I said, like immediately after, or? He said, shortly after, at any time. And I said, I don't recall. He said, you've never made any kind of statement to that effect? My lawyer says objection, asked and answered. The judge says overruled. I said, I don't recall. I stream every day, 8 hours a day. I make a lot of statements in a lot of different areas, so... Okay, and a lot of areas includes discussions about this particular case, correct? I said, correct. All right, and you make money off of your streams, correct? Well, yes, correct. So you're actually monetizing this lawsuit by virtue of the streaming that you do relating to this case, do you not? I said, narrowly, yes. Broadly, no. I've lost far more than I've gained from covering the public filings. And then he shovels his papers for a bit. He has to ask for a moment. Just a moment, Your Honor. And then he redirects a different line of questioning. Have you had other individuals claim that you have shared their videos, their sexually explicit videos, without their consent? And then I asked, do I need to answer that? Is that relevant to this? And I think the judge, there's no thing here, but I think the judge says yes. And then he asks how many. And I said, I can't recall off the top of my head. He says, okay, more than 5. I said, I don't believe so. He said, less. So other than Miss Doe, if it's less than 5, how many? And I said, the nature of my work and the nature of the world that I exist in, a lot of people make a lot of claims at different points in time. Some change, some come and go, so I don't want to speculate. Okay, you met Abby MC in approximately 2023, did you not? It sounds correct. All right, you had a sexual relationship with Abby MC, correct? Correct. All right, you're aware that Abby MC is indicating that you shared the video of you and Pxie with Abby MC in 2023, correct? I am aware of her saying that, yes. And then the judge says, well, do you recall doing that? And I said, no. The judge says, I'll rephrase the question. Did you in fact share the video of the plaintiff with this Abby person in 2023? I said, no. Like I said, I went back and dumped my messages and I can read everything I sent to that person prior, so. And then her lawyer says, of the videos that were posted to Kiwi Farms, how many videos were posted? I said, unfortunately, I don't know. I think it was in excess of 25 plus. And then her lawyer stupidly asks, had you had consent from all those other 24 individuals to share their videos with Rose? And I said, 24 individuals? And he said, those 24 individuals that you had had relationships with. And I said, the majority of the content posted on Kiwi Farms were solo videos featuring only me. I believe it was only, I might want to say 6-ish videos or maybe 5 videos, 5 or 6 maybe of involving other people. And I don't think it's 5 or 6 unique individuals. I think overall, I think it was 3 or 4 other individuals. So, and then he says, one of those 3 or 4 individuals, did you have consent to each and every one of them to post those videos? I said, publicly, no. To share them with other people, I would say yes. You would say yes? Yes. Are any of those 3 or 4 individuals, any of the other individuals that are making claims against you for having shared their videos without their consent, and I'm talking about other than Miss Doe? Andrew says, objection, there are no other claims, Your Honor. There's one plaintiff in this case. The judge says, I didn't understand your question. And then her lawyer says, let me ask you this question. Did you post them on that, what is it called, again, Kiwi Farms? Or the judge is asking me this, I think. I said, it's called Kiwi Farms. And the judge says, Kiwi Farms, did you post those videos? And I said, absolutely not. And then he says, okay, do you know who posted the videos? I said, if you'd like, I can speculate, but I don't know, unfortunately. And the judge says, you don't know the answer? And I said, I have an idea, but it was whoever had access to the account that I was initially conversating with. I think a different person gained access to that account, scrolled up, saw a bunch of messages, and then decided to, well, first they tried to blackmail me, and then they dumped all of the material onto Kiwi Farms. And then the judge says, I see. And then her lawyer says, however, you have directed your followers to those videos on Kiwi Farms, correct? And I said, what do you mean when you say directed? And he said, okay, you streamed or written about the existence of those videos on Kiwi Farms and indicated that the video of you and Pxie is available on Kiwi Farms, correct? And I said, I don't like the framing, but I have complained that my content was still being hosted there, yes, and nothing was being done about it, despite all the people talking about it, yes. And then the judge asks me, now, when is the first time that you found out about this Kiwi Farms postings? And I said, I believe I was in the shower and I think I got a text message from plaintiff. And the judge says, so that November 28th or 29th event is the first time that you found out about it? And I said, that all of my explicit material had been leaked? Yes. And the judge said, right, okay. And then her lawyer says, when you were contacted by Miss Doe, did you in fact tell her, look, I'm sorry, there's no excuse for this? And I said, that's part of my message to her, yes. And he said, all right, you've since deleted some of those messages, have you not? And I said, from Discord, yes, although I preserved copies of them for my records. During one of your live streams after this case was initiated, you published Jane Doe's name, did you not? And I said, I believe it was the same day. I think there was a filing for the protective order for I believe on the 19th, I think. So the answer is yes. And I said, can you restate the question? He said, yes, you posted or made available through streaming Miss Doe's real name, correct? I said, her first name, yes. If I can add, after I was made aware that the protective order had been filed, under advice I removed the reference to her name on that YouTube video, though. He said, you don't have anything in writing wherein Jane Doe consents to you sharing explicit material of her with you, correct? And I said, correct. A bust to other people? Yes, correct. Then the judge says, now let me ask this question. One of the arguments for the motion is that based upon what has transpired, there's still a risk that you're either disseminating or not actively removing her videos from the internet. What's your response to that? And then I said, so I think if we were to go through the declarations, I think plain text reading in the declarations, it's obvious they're not referring to those videos. So it's a declaration on the record by Hannah Brooke where I'm speaking about performing a certain sexual act. There's not a video that has anything to do with the plaintiff, although they've provided that. Wait, does that make sense? There's not having anything to do with the plaintiff, although they've provided that. They've stated that? Maybe that's supposed to be a different word. I don't know. The only evidence in the record so far, there's other evidence mentioning other people, but in terms of the video that's the subject matter of the complaint, the only evidence in the record is with the ABMC person, and that's them claiming that I sent them 2 videos. So one person of which I've never even taken videos with. So just to be clear, this Hannah Brooke person tried to like honeypot me, where they started talking very sexually with me, and then they tried to lie about like the videos that I was sending them or offering to send them. I wasn't even offering to send them. I was joking about them being up on kiwi farms. But like by the way that I'm talking, it's obvious that I'm not talking about anything having to do with me and Pxie. Although they lie about this multiple times and they've stuck this in their thing multiple times. I think they finally dropped that. I don't know if they're still carrying that on. But the judge also noticed this when he made the rulings on the preliminary injunction, thank God, that whatever I'm talking about with Hannah is not the same video in this complaint. So this is all just a lie that they're throwing shit up on to see what sticks, I guess, or whatever. That Hannah person is such a fucking schizo. She's always in the comments on the sex tourist fake lawyer guy's videos. If that's true, that's funny. This is a person that I talked with non-sexually for like 1.5 years. Apparently she used to have like a heroin addiction or still does. And she only got sexual or like hinted at sexual stuff with me after this lawsuit, I think, was filed, or after Pxie made her Substack. And I guess it was to try to honeypot like some statement out of me that she immediately ran a Jiskel's Discord server with and then took to Pxie to try to fill a declaration over. But it doesn't say what they wanted to say. It's really ridiculous. And she deleted parts of her messages to me before she pasted them, which is even funnier. Like where she calls like Merc crazy and shit because she didn't want to look like she wasn't like supporting her queens. But cringe and stupid and perjury, but whatever. And the judge says, and when did that supposedly occur? And I said, I believe, when did the declarant testify that occurred? And the judge said, no, when did you supposedly send the videos? And I said, I think that she claimed sometime in 2023. And then the judge says, okay. And then in terms of you are not doing enough to remove her video from the internet, what's your response to that? And then I respond, so there's 2 parts. So the first part is that I don't know exactly when, but several years ago, a lot of large pornographic websites like Pornhub and everything, there were new federal laws that made it very strict about who could upload materials onto those sites. So as a result of that, the only websites now that host explicit material don't seem to respond much, unfortunately, to emails. So for one website, I tried to email the website itself. Then I tried to email the hosting provider, like the internet company that hosts the website, and I got no response. For the main distribution center, which is Kiwi Farms, I said that I had my assistant send a message to the owner of that website. Online, his name is Noel, and he reposted that, actually, I think a week ago, making fun of me because that guy had a personally bad relationship with me. So it's hard for me I can't really do anything to take anything down on Kiwi Farms. I have no power over any of these other platforms. All I can do is file a DMCA request, and then if they've got a form for revenge porn, fill that out. But all the reputable online porn sites don't host stuff like that anyway, unfortunately. And then the judge asks her attorney, any further questions? And then he says, yes. And then he asks me, so you met ABMC sometime in 2023, right? And I said, it sounds right, yeah. He says, all right, so the video would have been shared sometime in 2023, if that's a video you shared with her, correct? My lawyer said, objection, calls for speculation. It assumes facts, not in evidence. The judge says, overruled, you can answer if you know. And I said, I don't actually have to speculate because I believe in the declaration Abby referenced a specific date for when I transmitted the video. I have logs from that date. I did not transmit the video on that date. So, and the lawyer says, okay, that's not my question, sir. My question to you is, if there was a video transmission of the explicit video between you and Miss Doe, it makes sense that if you shared it with ABMC, it would have to be sometime in 2023 because that's when you first met ABMC, correct? I said, no, not necessarily. We could have transmitted it before meeting each other in real life. Okay. But you do have record of having sent her explicit, and then the judge stops and says, well, let me ask you this question. Do you have a specific recollection of transmitting some video to her? And I said, I don't personally have like a specific recollection mentally, but I have logs from that. And the judge said, I understand. And I said, correct, yeah. And the judge said, in terms of your recollection right now, you have no recollection of sending that video to her? And I said, no. And then her lawyer asks me, do you have a recollection of sending her videos that were explicit in nature? And I said, yes. And he said, now, we had talked previously about others complaining that you had shared their videos without their consent. Is there an individual that goes by the name of Cherry that has made a complaint that you shared her explicit video without her consent? Andrew says, objection, lacks foundation, lacks relevance. The judge says, overruled. And then the judge asks, how do you spell that? Or maybe the court reporter asks, how do you spell that? And then her attorney says, Chaiyery. It's a screen name. And then Mr. Ledge says, you can answer, sir. And then I said, I'm aware that she has made public statements like that. Yes. And he said, all right. And you have a Google Drive with the content of your sexually explicit videos, correct? And I said, kind of, although the phrasing of that is strange. They're trying to, one of the arguments too that they were running with legally, when I'm clarifying here, is because I know what they're trying to like be vague or ambiguous about. They tried to claim at some point that I just have like a Google Drive with every video that I've ever recorded. And I'm just like throwing these out to people like, oh, here's like a link to a folder with every video that I've ever recorded on every, like this is, so I'm being careful to clarify here when they ask me these questions. So he says, or so I respond, kind of, although the phrasing of that is strange. I have a Google Drive, and within the Google Drive, you can create explicit links to individual files. So yes, I did not have a Google Drive where it was one link to a folder full of explicit material. Okay, and you would use that Google Drive to share explicit material. I said, correct, I did with plaintiff. He said, so on this post on March 19th, 2020, is that the Google Drive you're referring to? I think he puts a screenshot of something up, and I say, yes. And then he stops here. I believe I'm done, Your Honor. Let me just check with counsel, and I'll tender the witness. We'll tender the witness, Your Honor. Thank you. And then the court asks any redirect. And then Andrew, my lawyer, says very briefly, Your Honor. And he says, just a few questions for you, Mr. Bonnell. Since the filing of this lawsuit, have you transmitted the video of you and Pxie to anyone? I said, absolutely not. And do you have any intention to do so? Absolutely not. Well, lastly, you heard Ms. Doe claim that she suffered, a slew of harm as a result of the conduct that she alleges in her complaint. Mr. Bonnell, have you suffered any harm as a result of plaintiff's conduct here in the filing of her lawsuits? Objection, relevance, Your Honor. My lawyer says, there's a balance of equities. It's absolutely relevant. And then my lawyer, or her lawyer says, it's not even alleged. And then the court says, overruled. And so Andrew says, again, you could answer and please. And I said, yes, of course, yeah. And he says, can you please explain to the court what harm you've suffered as a result of the plaintiff's conduct? And I said, there's a direct monetary loss. There was at least one decently large sponsor that canceled their engagement with me. I believe it was for a low five-figure amount. And again, I've lost tens of thousands of subscribers on my YouTube channel. I think that the revenue for that channel tanked at least $50,000 or $60,000 over the course of 2 or 3 or 4 months. Reputationally, obviously, this is something that gets dragged out a lot by everybody on the internet. And personally, it amplified all of these videos a ton. And now more people are posting even more of the content. Sometimes people message my minor son, and they send him these videos now. But yeah, it amplified basically everything related to this. Andrew says, thank you, Your Honor. Nothing further. The judge says, you may step down. Thank you. I say, thank you. I should have said, thank you, Your Honor. L. He said, no additional witnesses. Correct. Their lawyer says, correct, Your Honor. Okay. And then now the next is just them questioning, and my lawyers. Okay, then let me turn to the plaintiff and tell me what, in light of the evidence that we've now gathered, what relief can I enter? Her lawyer says, Your Honor, I believe that the court is empowered to grant the issuance of a temporary restraining order and a preliminary injunction in regards to this case. Wait, is my shit big cucks? Okay, hold on. We'll wait a minute or two. Okay. Are we good? Okay. As a matter of fact, the statute that we're traveling under, the federal statute CARDI, contemplates it explicitly within the statute itself from further dissemination of the video, from posting it in any way. There is in the case law, it talks about the fact that this is an ongoing and irreparable harm to the plaintiff that doesn't really need to be proven under the case law. And then the judge says, what happens in a situation where the dissemination occurred long before? Is there an injunction in that situation? Has there been case law developed under the statute relating to that situation? And their attorney says, when you mean long before, Your Honor, could you give me a scenario? And the judge says, in other words, their argument is that this occurred back in 2022 or 2023. And then Andrew corrects and says 2022. And then the judge says, they're disputing 2023. You have evidence that it had to have occurred in 2023, right? And then their attorney says, correct. And then The judge says, so, putting that dispute aside, it either occurred in 2022 or 23. The question then is, though, is there any evidence of anything in the more recent time? And then their attorney says, yes, Your Honor, there's evidence of more recent time because the video itself wasn't uploaded until 2024. That wasn't me, by the way. Then, after this lawsuit took place, there's evidence that the defendant was talking about this on the stream, was directing people to the Kiwi Farm site and to the other sites, and there's references to his Google Drives. He's never said that he's deleted these images, although we've requested that he do so. We've asked him to cooperate with Kiwi Farms. Despite him saying that he was wanting to take them down, there was no cooperation in any way, shape, or form. That's a lie, by the way. We agreed that we could request him to take them down, but they only wanted to take down her 4 videos, not any of the other ones involving me, or like one video for her or whatever, and then like images that people had posted, but nothing else of mine and nothing else of any other women involved, by the way. So that's why we didn't agree to that court order. The efforts were lacking in a very kind way of putting it. The efforts were lacking is a very kind way of putting it. We agreed to take all of it down, but they just didn't want to. They only wanted to take down her stuff. It was insane. And yet he says on the one hand that he wants to take them down. We have a motion pending to have it taken down, and he has the ability to oppose that, just for the purposes of trying to re-argue this subject matter jurisdiction, which is a question of fact that ultimately would have to be determined either at summary judgment or a jury trial, vis-a-vis the special verdict interrogatory, if we even get to that point. So we brought up subject matter jurisdiction, which is, can the court even hear this case, which they really shouldn't even be able to because they have no evidence for anything, and they're mad that we're arguing this, and they're saying, well, no, that's the jury has to figure this out. And at this point, I guess, Ms. Abby Pxie would have been deposed and will testify at trial if need be. And at that point, I guess, he's saying, Abby Pxie will have been deposed and will testify at trial if need be, but we don't have to make a showing that we are going to win for sure. There just has to be a likelihood of success in the merits. I think we've proven the 4 elements necessary for the issuance of a temporary injunction or preliminary injunction. And the harm is, by the way, they lost on all 4 elements, not even just one. They only need to lose on one, but they lost on all 4, by the way. And the harm is ongoing. As long as this is on Kiwi Farms, where he has access to these videos and he can post them at any time, Miss Doe is suffering irreparable harm. And the case law talks about it, that as long as it can be posted, there is an irreparable harm. It's presumed. So if the question is about irreparable harm, I can point the court to the Doe versus Constant case. This is not true. Irreparable harm is absolutely not presumed. Otherwise, it would be an automatic preliminary injunction, and there wouldn't just be statute. This is just a brain-dead statement. It's 2024 Westlaw 3512136 and it says, since continuing harm via continuing disclosure, as contemplated by the statute, injunctions are commonly granted. Continuing harm is not the same thing as irreparable harm, and you can have continuing harm. The whole point of winning a case is to redress that harm, but this is just stupid. So then the judge says, now if I were, what kind of an injunction are you asking for? And the lawyer says, well, I think we spelled it out in our moving papers, but, and the judge says, no, I didn't think you really did. And her lawyer says, well, we're asking that. And the judge says, that's in part why I set the hearing, because I wasn't actually sure. I mean, you said it very broadly. So how would you write the injunction? And he says, well, how would I write the injunction? Well, the injunction would say that Mr. Bonnell is prohibited from further dissemination of the video, from further directing people to its video until it's taken down, from commenting on the video itself or the images contained in the video while this case is pending. And the judge says, okay, and would it include... Okay, fuck. Hold on. I'm just going to kill my kick stream because apparently it's lagging a lot and the people in chat are losing their minds. Sorry. I love you, kickers. Just go to YouTube, okay? Kick stream is down. Okay. Hopefully also YouTube stream as well. We're 2/3. We're almost done, okay? We can do it, guys. Over 2/3 of the way done. Are we good on YouTube? Everybody, anybody? Say fire truck if we're okay. I don't know if anybody can see anything. Okay, it's a little laggy. Refresh, I think. Okay, if you need to. Okay, the idea of the owner of the website, Noel, saying that like he'll take something down, he has no problem with that, but he needs a court order first is ridiculous. I don't know what this, like, if you're willing to take something down, just take it down. Why would you need a court order? It's so silly, but whatever. The judge said, and talk to me on the subject matter jurisdiction. Explain that to me with a little more detail. Their attorney says, well, Judge, with subject matter jurisdiction, what they're trying to argue is that since the original transmission with Rose took place in, they say, April of 2022, and we say, October 4th of 2022, that there's no subject matter jurisdiction because Cardi wasn't enacted until October 1st of 2022. So, if it happened in April, there was no subject matter jurisdiction. The injunction doesn't have to be issued just by Cardi, although we believe that Cardi, that's the first cause of action on the suing matter, although we believe Cardi gives an ample basis for it because we cited to the Florida statutes that prohibit this as well as intentional infliction of emotional distress. Now, intentional infliction, that requires me to be like malicious, like I'm posting this just to fuck with Pxie, which is insane, okay? There's other causes of action which would warrant the issuance of the temporary injunction and preliminary injunction in this case. But then we also turn to the issue of the dissemination to LBMC and his direction of individuals to the site where it's being posted. So that's additional dissemination, we believe, under the statute. It's crazy. The judge says, okay, take it a step at a time. With respect to the April issue, you haven't introduced any testimony differently, right? You haven't introduced any evidence at this point that disputes or that directly contradicts the argument that it was European time. And then they say, well, Miss Doe testified that it was October 4th. And the judge says, but she has no personal knowledge of them looking at what she's looking at. And he says, right, and I don't disagree that that's an issue that's in dispute. And the judge says, right. And he says, but, and the judge says, so let's assume that it was in April, just for the sake of argument. Assume that the communication was in April, such that the communication falls outside the statute. What injunctive relief or what legal basis do you have for an injunction in any event? Her lawyer says, if that were the case, I would have Florida statutes which provide for the issuance of the injunction as well, Your Honor. You can issue the injunction under Florida statutes as well. And then as a basis, and the judge says, and specifically, which statute? And he says 784049. And the judge says, is there any statute of limitations type problem with the statute applying? He says, I don't believe so, Your Honor. I mean, if it was disseminated in 2022, a four-year statute of limitations puts us at 2026. So there's no issue with that. The judge says, right. And he says, but I think even under Cardi, the LBMC declaration, it's a he said, she said at this point as to whether or not she received the video relating directly to my client or not. And I think that would form the basis under Cardi. We also have the statement that was made to my client by the other individual that said that her video had been shared 2 months before the filing of the lawsuit. And that's in paragraph 323 of our complaint. By the way, they've never made that person available to us. We have no idea who that person is. I think they said now this person deleted their account. We have nothing. This just is like, it's triple hearsay. A person said that their sister said that they maybe had received a video of it. Like, this is so stupid. I think it's just a Kiwi farmer emailing her or DMing her, is my guess. All we have to do is show competent proof. It doesn't have to be proof beyond a reasonable doubt or clear and convincing evidence. It's a preponderance of the evidence at this point. And given that, we believe that we've put forth substantial competent evidence, which would give rise to the court being able to issue the injunction at this time. And then the judge says, and last question, you learned about the Abby allegation when? And they said, Your Honor, I believe that we learned about it during the course of the lawsuit. And then the court says, so after the lawsuit was filed? Correct. There was one issue that we've considered is whether or not an injunction at this point is stale based upon A, the allegations of the complaint talking about when the dissemination occurred, B, the afterknowledge by the plaintiff of the infringing activity that no effort was made to seek injunctive relief until months later. How do you respond to that? Well, Your Honor, I don't think it's stale at all because the issue arose in November of 2024. That's the first time that my client ever became aware that her video had been shared with anyone without her consent. After that, she made efforts to contact Mr. Bonnell to handle this matter amicably to see if they could be taken down. Mr. Bonnell led her on, told her that he was making efforts, that he hired a law firm, that he hired a private investigator, and he delayed that proceeding. I didn't lead her on. All of these statements are true, but okay. Then the lawsuit was filed within months of that, and the irreparable harm continues. The video is still available. It's still being disseminated. It could be disseminated at any time, and Mr. Bonnell himself could disseminate the video without an injunction prohibiting from doing so. Monetary damages aren't enough or a substitute for an injunction under these circumstances. And the case I cited to the court, the Doe versus Constant case, makes that abundantly clear. So under the circumstances, I think that Your Honor is well within his rights to issue the injunction that we seek. He says, thank you. And then Andrew says, thank you, Your Honor, because they call my attorney up. Personally, Judge Becerra already denied the TRO. That's the main judge in my case. We're talking to the magistrate judge right now, which is another judge brought in to help with cases when there's a high volume basically through the court. So plaintiff's counsel's argument that a TRO issue is moot, the court has denied it, finding that the TRO was stale. Plaintiff found out about these videos in April. It's now June, and she's seeking a preliminary injunction. Judge said, you said April, did you mean? Andrew says, I'm sorry, you meant November. And then he says, November of 2024. It is now June of 2025. The court has already determined that there was no emergency. The court has already determined that the request for a TRO is stale, and so is the request for a preliminary injunction. Where is ABMC? Plaintiff's counsel has represented to me that she was a client of their firm. They said that initially, by the way, and now they've said she's not. I've asked them to accept service of a subpoena on her behalf. No response. We have a hearing in court today where her testimony would be critical. She is nowhere to be found. We have no evidence whatsoever that this court has jurisdiction over this dispute. There is no federal question. The statute that they are suing Mr. Bunnell under did not even exist at the time that the video was transmitted. And this Florida statute that they're suing on for, under a theory of supplemental jurisdiction, because there's no diversity between the parties, requires malicious intent. That's the Florida statute. It requires Mr. Bunnell to have published the video himself onto a platform. He did no such thing. That's why they try to make this argument that when I share a video on Discord, it counts as like a public posting, which is ridiculous. But that's why they keep leaning on that, because they need that for their other claims, basically. These two individuals are part of an online community where they share sex tapes with each other, and it is not out of the question that a sex tape gets leaked. And it is just not something that this court needs to be involved with in terms of issuing an injunction for conduct that did not even occur since the statute was enacted. You've heard from Mr. Bunnell today. He was forthcoming, he was clear, he was honest. You don't issue an injunction based on conduct that took place months ago, or what plaintiff is afraid might happen in the future when there has been no evidence of any dissemination by my client personally at all on any website, and secondly, since the enactment of the statute. So the court not only does not have the authority to issue a preliminary injunction because it lacks subject matter jurisdiction over this dispute, but even if it did have that authority, even if there was a scintilla of evidence to show that this video was transmitted post the enactment of the statute, there is no further conduct to enjoin. There's no conduct to enjoin. Mr. Bunnell testified he is not publishing the video. He hasn't published the video. He has no intention to publish the video. He has taken measures to try and remove the video that other people have published. He himself is being harmed by this. Why didn't plaintiff sue Kiwi Farms? Why didn't plaintiff sue these other websites that have allegedly published the video? Mr. Bunnell doesn't control those sites. Mr. Bunnell can't force Kiwi Farms to do anything. He can ask, but Kiwi Farms is out of jurisdiction. Kiwi Farms is a corporation based in Texas. They filed a motion with this court asking the court to enjoin Kiwi Farms to take down the content, but according to plaintiff's own motion, Kiwi Farms will voluntarily do so. Why do they need a court order? Mr. Bunnell doesn't object to Kiwi Farms removing the content. What he objects to is forcing him to pay for their injunction. That's also a thing that they had, by the way. Forcing him to pay to have the court issue an order, forcing Kiwi Farms, a website he doesn't control or cooperate with, to remove his content. That's what he's objecting to. He's objecting to how arbitrary it is. We submitted a link of, 26 URLs of other content that Kiwi Farms is posting in addition to this video of plaintiff and Mr. Bunnell. They absolutely refused to ask Kiwi Farms to remove that content. This is one of the, it's a long time ago, but this is one of the most disgusting things that Pxie has done. I don't know if she's pro-revenge porn, if she thinks men don't suffer from revenge porn or whatever, but she refused to have me, because she basically said, here, how about we take down everything relating to me? Here's 4 links, can we do that? And my response was basically, okay, sure, but if we're going to make a court order taking things down, can we just take down every lit video? And they were like, no, I just want my stuff taken down. Not any of the other women, not you, just my stuff. If you want everything taken down, that you have to pay my court costs. Fuck you. How fucking disgusting. What a disgusting and gross thing to try to make a demand of. It's so, you claim you care about the other women harmed in the case. Obviously you don't give a fuck about me because she's on her woke yes queen hate men arc or whatever, but Jesus Christ. But anyway, they absolutely refused to ask Kiwi Farms to remove that content. They're focused on this one little video. And if Kiwi Farms and this guy named Noel wants to remove the video, God bless him, we hope he does. He doesn't need a court order from a district judge in Florida to tell him to take down the content. He should just take it down. And that, again, all assumes that plaintiffs can even meet their threshold showing of subject matter jurisdiction here. The court does not have the authority to act in this case, period. That's what the judge ultimately agreed with. It just doesn't. The case should be dismissed. Oh, no, wait, I'm sorry. They haven't agreed with this. They just, that's not true. Sorry, I misstated there. Doesn't have the authority to act in this case, period. I thought he meant in this case as in the case of the preliminary injunction, but he means in the whole case. It just doesn't. The case should be dismissed, and they have had every opportunity to show that subject matter jurisdiction lies, and they failed. And the judge asks, why is there no diversity? Where are the people from? And Andrew says, they're both here in Florida. And the judge says they're both Florida people. And then Andrew says, yes, they're both here in Florida. There's no diversity jurisdiction. This is a federal question case where they've tacked on state law claims that they have absolutely no bearing on this dispute, because they have different standards. They require malicious intent. They require an extortion element. They require posting directly onto websites. Mr. Bonnell did none of that. The judge says, where do you get that, by the way? And then my lawyer says, in the Florida statute. And the judge says, yeah. And Andrew says, we did a lot of research on Florida case law that seemed to require malicious intent by the defendant. Malicious intent to cause harm to the plaintiff financially, etc. And all of the local cases, the Florida state cases interpreting that statute, focused on the malice element. There is no malice here. There's been no showing of malice, but more importantly, there's been no showing that there's been any transmission post-effective date of CARDI, and the case should absolutely be dismissed at this early stage. And the judge says, because if you were in state court, the court could enjoin it because he didn't post on an internet's website, but he disseminated it through electronic means. And Andrew says he disseminated it to Rose back before the federal statute was enacted. The court says, right. Andrew says he did not do so with malicious intent. He never identified plaintiff by name, never identified plaintiff by screen name, never said, this is so-and-so, you should, here's a video of her, never to cause her harm. They're part of a community that enjoys sharing sex tapes with each other, and they publish them online. It might not be normal for us or for the general public, but it is certainly normal in their community. And there was no evidence that Mr. Bonnell did anything to harm Pxie, to harm the plaintiff. He, in fact, immediately expressed that he was upset that the video was published outside of his control. Clearly, there was someone that hacked Rose, or Rose, published this material on his or her own. We don't know who Rose is, but it's not Mr. Bonnell that had any malicious intent to harm plaintiff. He's harmed by this. Mr. Bonnell is the one who's the victim of revenge pornography here. We heard testimony earlier today about the website crashing because of Stephen Bonnell's quote-unquote blowjob video. It was a completely different video that had absolutely nothing to do with the plaintiff that crashed the Kiwi Farm site well prior to this lawsuit even being filed. It had nothing to do with the plaintiff. That video that crashed the site was from Mr. Bonnell and another sex partner, and it got a lot more views than any video that that ever wound up being published of him and the plaintiff. And those videos that were published of him, the plaintiff had, certainly did not originate from Mr. Bonnell's transmission. That's the bottom line. This court doesn't have jurisdiction to enter the injunction that they're requesting, and there's no conduct to enjoin. There's just no more ongoing harm. Why are we here in June if this alleged conduct, if this allegedly caused plaintiff to feel suicidal in November? It doesn't make any sense. And then the judge asks the other lawyers, do you want to reply? And then her attorney said, briefly, Your Honor. As far as the staleness issue, the issue relating to a temporary restraining order as opposed to a permanent injunction are two different standards as far as the time frame is concerned, and the Doe versus Constant case makes that abundantly clear because the permanent injunction was issued months after the conduct took place. In that particular case, the disclosure of the materials took place in August of 2023, November 2023, and January 2024. They filed the lawsuit, and it wasn't until July 23rd, 2024 that the permanent injunction was issued. So that addresses one of the issues as far as staleness is concerned, and then the court also says the court can see no harm to defendant in foregoing further distribution or displaying of plaintiff's intimate photographs. On the converse, the court can foresee a great deal of harm to plaintiff should the intimate visual images of her continue to be disseminated. Accordingly, the balance of equities weighs heavily in favor of an injunction, and there is no harm for the public in granting the requested relief. So, Your Honor, I think that this case is on all fours as it relates to almost the same set of facts that are applicable on this particular case as far as the time frame when our client knew or should have known that this has been posted and disseminated. As far as Kiwi Farm's argument that they're positing, it's just bootstrapping to their argument on subject matter jurisdiction, which is more than adequately a strapbush, through the ABMC declaration in paragraph 23, adequately established through the ABMC declaration in paragraph 23 of our complaint, even if we were to put aside the issue of whether or not the initial sending of the video was in April as opposed to October in this matter. Accordingly, Your Honor, and then the judge stops and says, did you allege the ABMC incident in the complaint? Ooh, they did not. No, Your Honor, it wasn't part of the original complaint. It's part of the evidentiary submissions in this case, but we do reference paragraph 23, which is the other attempt that he made to disseminate it to another individual a few months before this lawsuit was filed. And also, Your Honor, and then the judge says, and what evidence do I have of that? What evidence do I have of that? And then their lawyer says, well, she testified as to that today as well, Your Honor, that she had contact with an individual that had received the video from Mr. Bonnell to her sister. And hearsay is admissible. This would be double or triple hearsay, by the way. And hearsay is admissible in this type of proceeding. And you can give it the weight that you believe is appropriate under the circumstances, given Mr. Bonnell's proclivities for disseminating videos on a very constant basis. Also, Your Honor, I think that it's important to note that he has been continuing to make it accessible vis-a-vis Google Drives. So it's an ongoing dissemination as long as it's being disseminated or accessible on his Google Drive, which were posted publicly. That's not true. That's a fucking lie. He says, response to his argument that I can't rely on the statute because there's been no evidence of malice in the dissemination. And then this is the dumbest argument that they try to roll with. Your Honor, at any time that you violate somebody's trust in this fashion, there is malice. He knew that he didn't have the authority to disseminate it, and therefore it's malicious. It's not, he didn't say, oh, well, I texted it by mistake. I didn't intend it to send it to Rose. It was, I hit the wrong button. That's not anything that he's testified to. He sent it deliberately. And that, in and of itself, is malicious when you are sharing the intimate graphic details of a sexual encounter that you have no right to share with a third party without the consent of the other individual. I think malice is implicit in what Mr. Bunnell did in this particular case. And then the court says, well, the statute says that you have to disseminate through electronic means. And then her lawyer says, he texted it. And then the judge says, a sexually explicit image of a person that conveys the personal identification information of the depicted person. What does that mean? They say, Your Honor, I think can the person be identified as a result of the video that's been disseminated? The case law isn't clear on that, but what we do know is that numerous people, even the testimony from Ms. Doe, is abundantly clear that everybody could identify who she was, and they were posting about it, they were texting her about it, they were DMing her about it, so it's clear that it was her. So I think that's sufficient to meet the criteria under the statute. And then the judge says, then the next provision says, with the intent of causing substantial emotional distress to the depicted person. And then her lawyer says, Your Honor, so whenever you do that, oh God, this argument is so scary. Your Honor, so whenever you do that, you know that the possibility, well, not just the possibility, that it will cause distress of the other person, to the other person if that does come out. And we have the testimony of Mr. Bunnell himself, who says that there's no secrets on the internet, okay? And he also said that posting without somebody's consent is one of the worst things that you can do. And implicitly, it's because we all know that that's going to live in cyberspace in some form or another for eternity, and that's going to cause the distress of that particular individual. And the judge says, well, I guess their defense is that his quote-unquote community that she participated in are basically people who routinely do this. And so, therefore, even assuming that he made a mistake about what he believed to be her consent, let's assume that he didn't do it with the intent of causing her distress because he thought that she was part of his community. So this is funny. They're trying to shift the intent of that statute to a different part. The intent isn't whether or not you had consent to do or not do a thing. Even if you don't have consent, the intent part is do you intend to cause them emotional harm, right? And they're making this like per quad argument of like, well, anytime you do it, obviously there's an intention to cause harm, but that's not necessarily true. That's stupid. You could like share an intimate video or picture of somebody, even if you know that you're not allowed to, but you're still not intending to cause harm to that person. You could just be gooning or whatever you want to say, right? Like there's not that the intent part isn't on like just the, did you send a thing, right? And then their attorney says, the problem is the internet isn't relegated to just his community. The internet is the public at large. So, and the judge says, but he didn't post it on the internet. He sent a text message. And they said, I understand, but, and then the judge says, because it would be different if he posted it on, say, a Substack, right? Now, I don't know if the judge was like referencing kind of snarkily the fact that she made a Substack talking about all of this or not. I don't know if that was the intent there or not, but that was, I don't know, that's kind of a funny line from the judge. And then her lawyer says, well, he has, and then the judge says, but if he sends a text message to an individual, and then that individual either disseminates it without his consent or gets hacked, the question is that what the statute is going at? In other words, is that what, why would you have if you post that on an online community, knowing that millions of people or thousands of people are going to see it, malice can be presumed at least, right? At least in the initial stages. But in a situation like this, how do I know that? And they say, well, Your Honor, there was no caveat whatsoever that Mr. Bunnell had placed on the dissemination of that video with Rose. He didn't say this can't be shared, this can't be posted. And then the judge says, well, even if he did, it wouldn't have mattered because if it is true that she was hacked, right? This other person, Rose, any of those disclaimers, any of those caveats would have been made irrelevant. And the lawyer says, well, and that's what we're assuming based on his testimony is that they were hacked. We don't have any evidence. And the judge says, right, we don't have any evidence of it, right? And then their lawyer says, of course, at this time. And the judge says, right. And then their lawyer says, but we do know that he disseminated the video without consent, that he knows that in and of itself, that person can do whatever they want with that particular video. They can send it to everybody in their group chat. They can post it online. They can do whatever they want with it. And in and of itself, knowing that that could happen, knowing that, as he says, nothing is secret in the streaming world per se, he knew that this was reasonably foreseeable, remember that word, foreseeable, and highly likely that at some point this was going to get out, and he had no regard for it. And he's had no regard for it in any of the time for the sharing of any of these videos. And then the judge accurately says, but if that were true, then she's guilty of cyber harassing because she sent a video of her former boyfriend So if it was true that simply putting it out there is sufficient, right, because once you disseminate, bad things can happen, then she would be guilty of it. She may not have had any intention of causing substantial harm or emotional distress to her former boyfriend because she assumed that she had consent, but she clearly disseminated it. So how is that any different? And then Horlier says, well, the difference is this, Judge. I think it may have been lost in her testimony, but she had consent from her boyfriend to disseminate that video. So he knew what he was facing, what the reasonable foreseeable consequences of that were, and what could happen with that particular video, and he consented to it. The difference here is that she did not consent dissemination of the video that she made with Mr. Bonnell, and that is the crux of the difference in these two scenarios. And the judge says, sure, because if in fact she didn't consent, then it makes a difference. The question, though, for me is, for purposes, that's a different issue. If she didn't consent and he violated their trust, then number one, you have a contractual arrangement, theoretically. Number two, you have at least a negligent infliction of emotional distress. The statute seems to require, to me, to find that at the time of dissemination, he did so with the intent of causing harm to the depicted person. So, do I have enough evidence at this point to make that finding? So negligence is different than malice, right? So let's say that I'm like sending videos to a bunch of people because I'm gooning or whatever. You could argue, okay, well, you're being negligent here, but the statute that they're citing requires malicious intent. Like, I'm not doing this with disregard for the plaintiff. Maybe you could argue that malice could rise if I post it to a website publicly, sure. But if I send it to a bunch of people, is that malice? You're going to need more evidence to prove that, right? And they said, yes, Your Honor, because I think it's reasonably foreseeable and he had the intent of disseminating it. So we know, first of all, he barely knows this person. He doesn't know Rose from a hole in the wall is basically what he's saying to you, Your Honor. He's known her for a couple months, talked to her on DM, and well, here's this private information about an individual that you know nothing about. Do with it what you will. There's no parameters to it whatsoever. And, he's using it to entice her maybe into the next sexual encounter. But to that, as it may, he has a habit of doing this, Your Honor. It's not the first and last time that he's done it. So this, by the way, this hurts your foreseeability argument, because if you're saying I've done this multiple times and it's never leaked before, well, how is it reasonably foreseeable that this would be leaked? Like you're arguing against yourself here, right? So I think that the malice is there, and I showed Your Honor the text messages leading up to the encounter where she indicates that she doesn't want anyone to know that they're engaged in a sexual relationship of any sort at the time, and that she trusts him and that he understands what consent means. He tries to spin it in a different direction, but I think it's abundantly clear what the purpose of that text was, or what the purpose of that Discord post was at the time that it was sent to him. The fact that he now wants to say, well, I thought I had implicit consent or some type of implied consent, implicit or some type of implied consent, flies in the face of what he received. So, I think under the circumstances that you have a number of ways that Your Honor is empowered to grant the permanent injunction in regards to this particular case. The judge says, okay, all right, so I'll take that all under advisement and issue out a ruling soon. Their attorney says, thank you, Your Honor. Andrew says, thank you, Your Honor. The court says, now I will say this, I'm not going to ask for it. There is some intersection between what we're dealing with and what's happening since, because, for example, I was going to say I wanted to grant the injunction and I felt that I had a good basis, or that I had a beat basis to, I don't know, and all the elements were met. Theoretically, that would include potentially mandatory injunctive relief, but that's relevant also to the pending motion on the Kiwi Farms thing. So there may be some overlap there, so I may consult with Judge Becerra about how we should handle that to be more efficient on our end. But I would take it a step at a time first, because obviously, if I conclude that I can't grant the injunction legally, then there's no overlap. At that point, then the other issue still stands that needs to be taken up on its merits. Andrew said, if they want to add Kiwi Farms to the lawsuit, then that's their prerogative. But right now, the only motion is for an injunction against Mr. Bonnell, and we've demonstrated that they haven't met their burden. Thank you, Your Honor. The judge says, thank you, I'll rise, and then that's it. Jesus. Ugh. Anyway, that was their hearing. Obviously, I think this hearing was a disaster for them. The fact that they lost event. This was what the ruling a few weeks or maybe a month ago was about. All of this preliminary injunction request failed on all four elements. It only has to fail on one, but it failed on all four. Yeah, what a meme. I might post the transcript publicly. Obviously, I have the whole PDF, but I don't know what the norms are. Oh, the C is Becerra. It has an S sound. Oh, Becerra. I can't roll my R's. Becerra or whatever. Sure. Since you went live, they also filed another reply to their Hague filing. I need to leave. I've been streaming for too long anyway, but. October 27th. Oh, that's today. 157 docket items. Oh, they're trying so hard to subpoena Molina, but it's like, bro, you guys are fucked. Like, it's so stupid. Like anything with Molina would have been way before the statute date. I don't know what you're hoping to get out of her. The fact that you're trying to drag her into this like so late. Why wouldn't you file the subpoena months ago? Why are you trying to use an international convention to do, like, it's so late. It's so late. You've fucked yourself. Yeah. Destiny, the transcript is on the docket. The whole transcript is posted now? Or are you just lying because you think that the motion ruling on it is the same thing as the transcript itself? Because you're a dumb fuck. Okay. Is it over now? It's still ongoing? Nope, it's still ongoing. They're trying to drag it out as far as possible. Oh, the full PDF is there. Thank you. Nice, based. Okay. Well, I love you guys. I think the thing tomorrow is pre-recorded. That Israeli debate that I did was not the actual debate that I did in the UK. I think that the UK debate, they emailed me and they said that the camera footage got messed up, so they might not have that. So I don't know what we're gonna do with that. I might go back to the UK and re-record. I'm already booked too tightly to do it this time, so who knows. Will the debate with the Muslim guy be live? No, the Oxford Union stuff is done. It's pre-recorded, so yeah, I do that tomorrow, and then I'm gonna be in Nebraska for Halloween for Nathan and everything. So all right, my next stream will probably be like on the 3rd, assuming nothing else blows up in the world, I guess. Jesus Christ. Oh no, on the 3rd, I'll be at Virginia Tech. If you want to come and see me, I'll be at Virginia Tech on the 3rd, okay? All right, be careful. It's not enough that she's weaponizing the court system. She also has to weaponize international treaties. It seems he still didn't understand the plaintiff's gathering video game achievements. Yeah, true. Any Amaru Miskiff memes? Those were crazy. Good luck, Miskiff. I don't think his response was all that great, but... All right. I love you guys. It's been fun. Hopefully, I should be live on the 3rd at Virginia Tech. Be careful. We're burning cappuccino, 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 Doritos. I'll catch you guys next. Why isn't this on your Google schedule? The Virginia Tech thing is on my schedule. Pretty sure if you go to destiny.gg, I think it should be there, isn't it? Consider countersuing? Maybe. I mean, I want to. Yeah, I'm going to be pushing as hard as I can for it, of course. Considering how she's wasting so many different... Oh, and there's like, trust me, there's worse. There's so much worse. But I have to wait for a month or two whenever that gets out. My God. But we'll see. All right. I'll let you guys have fun. Rip on.